Ярославович. Доброго
Доброго
ранку,
ранку.
Микола Петрович.
Доброго ранку всім. Микола Петрович, доброго ранку.
Здрасте, Ігор. Раїса Федорівна, вітаю. Оля.
Як там Харків, Микола Петрович, сьогодні? Ніч яка?
Раїса Федорівна, ну, ви знаєте, як завжди. То безпосередньо по Харкову якогось такого непередбачуваного нічого не було. По окраїнах били, Лозова і так далі. Були прильоти і РСЗО, і КАБи. Ну, так, пробіг по новостях.
Да,
Попередньо
Господи
все.
всім.
Ну, в Києві воно ж
О,
не
Ірина,
менш
да, Ірина
тихо.
Леонтівна наша з'явилася. Доброго ранку, Ірина Леонтівна.
Доброго ранку, Раїса Федорівна. Доброго ранку,
Доброго,
дорогі колеги.
доброго, доброго.
Доброго ранку. Доброго ранку. Секундочку. Що мене видно?
9-та міжнародна науково-практична конференція «Адміністративна юстиція в Україні. Проблеми теорії та практики. Публічні фінанси в умовах війни. Особливості правового регулювання та правозастосування».
Доброго ранку, шановні колеги. Доброго ранку, шановні учасники нашої
Good
9-ї
morning, dear
міжнародної
colleagues, dear
наукової
participants of
практичної
our 9th
конференції.
International Conference.
У нас другий день роботи.
It is day two of our
Я щиро
proceedings.
всіх вітаю. Бачу, нас
Welcome,
зараз
everyone.
підключилося
I can
82
see 82 participants connected, and gradually more people are connecting. Today is our third and fourth session focused on national module, national enforcement in public finance under the conditions of war, financial liability, and other issues of enforcement of tax law under the conditions of war. When we were drafting the agenda, we made the topics more extensive because the problems are quite wide, there are many issues, and not to tie those who want to be published, who want to make a presentation, for them to have the choice. Today's third and fourth session will be moderated by the judges of our chamber, by the Supreme Court judges, by the Cassation Administrative Court judges, our distinguished colleagues, Doctor of Legal Sciences, Irina Leontivna Zheltobruch, and Igor Yaroslavovich Olender. We wish you success, and as Natalia Evgenievna is saying, the audience is yours.
Доброго ранку, шановні колеги.
Good morning,
Радо
dear
вітаю
colleagues.
вас усіх на другому
Welcome
дні
to the second day
міжнародної
of our
науково-практичної
international
конференції,
conference.
дев'ятої по рахунку,
It is 9th
з
international
темою
conference
«Публічні фінанси
dedicated to
в умовах
public finance and the
особливостей
conditions of war,
правового регулювання».
peculiarities
Якщо
of legal
попередній день
regulation.
був присвячений
Day one was
більш
dedicated
порівняльному
mostly to
історичному
comparative historical
аспекту,
aspects,
конфлікту принципів права та
the conflict of
ідеї
principles of
балансу,
law
то
and
сьогодні
striking the balance.
в фокусі нашої
Day
уваги
two
більш
will
предметне
focus
обговорення.
on more specific
Ми
discussion.
прообговорюватимемо
We are
питання
going to discuss
правозастосування.
enforcement matters.
І не відволікаючись
And
на вступні слова,
without further
хочу
ado,
перейти
I'd like
безпосередньо
to
до
move
третьої сесії
directly
нашого
to
заходу
session 3 of
і
our
надати
event
слово
and
видатному
give the floor to
юристові,
distinguished
професору,
lawyer,
доктору
professor,
юридичних
doctor of
наук,
legal sciences,
кандидатові економічних
candidate of
наук,
economic
першому
sciences,
проректору Національного
first
юридичного
vice rector
університету
of National
імені
Legal University
Ярослава
named
Мудрого,
after
нашої
Yaroslav Mudry,
альма-матер,
our alma
дійсному
mater,
членові академікові
the member of the
Академії правових наук
Academy of
України.
National Academy of Legal Sciences of
Лауреатові
Ukraine,
Державної
the
премії
laureate of
України
State
за
Award of
ознаки
Ukraine in the area of
першого
science and
заступника
technology, first
міністра
deputy
юстиції, члена
Minister of
експертної
Justice,
ради і, що
member of expert
особливо
council,
важливо,
and what is especially important for us as
кандидатів
judges,
до Вищої ради
candidates to the
правосуддя.
Supreme Council of
Нині він
Justice.
ще й старший офіцер
Is
відділу
also a
цивільно-військового
senior officer of the
співробітництва
Department of Civil Military
Штабу України
Cooperation of the
Другого
headquarters of the
корпусу
Second
Хартії
Corps of National
за
Guard
роботу у сфері
Charter
безпеки та
for
оборони
the work and
країни
security and defense of Ukraine.
Микола Петрович
Mykola Petrovich
Кучерявенко
Kucherevenko
нагороджений почесним
is
знаком
awarded to
міністра
with
оборони
the
знак пошани.
awards
Микола
of the
Петрович
Ministry of
один із
Defense.
співзасновників сучасних
Is one of the
концепцій
founders of
банкового
modern
та
concepts of
податкового права.
financial and tax law in Ukraine,
Співавтором науково-практичних
co-author of
доповідей
scientific
Конституції
comments
України,
to Constitution of
бюджетного та
Ukraine,
податкового
budget and tax
кодексів
codes of
України,
Ukraine,
фундатором школи
founder of
податкового
the
права.
School of Tax Law,
Сотні наукових
hundreds of scientific
монографій,
works,
підручників,
articles, monographies,
навчальних
textbooks,
посібників.
training
Його
manuals.
підручник «Податкове
His
право»
textbook on tax law
перевидавався 40
was
років.
issued 40
І
times.
сьогодні я
And
переконана,
today I'm
що для
convinced that
відкриття другого дня
to
нашої
open
сесії
day
не
2 of our
знайти
session, we
більш
cannot
влучної
find
кандидатури.
bad
Микола
candidates.
Петровичу,
Mykola
прошу,
Petrovich,
аудиторія
the floor
ваша.
is yours.
Дякую, дякую.
Thank you so much,
Пані Ірина. Я
Ms. Irina.
перш за все я хотів
First,
подякувати
I'd like
вам
to
за
thank
допомогу,
you
бо я так
for
розумію,
your
мій
assistance, as I
регламент
understand
вичерпано
my
після того, як ви мене
time is already
представили,
exhausted after the
і часу
introductions,
не залишилось.
and I don't have any more time left.
Дякую, багато чого
Thank
того,
you.
що ви назвали, це
Many
було
things that you
безумовно.
mentioned are in the past now, however,
Дійсно, я
in the present,
пробую, і я
I am trying, and I believe I'm successful to combine some research capabilities, analysis of problems, which in my view are urgent, with my current function as a member
учасника,
as a
як
participant,
особу, яка
as a
залучена до
person
Нацгвардії.
involved in National Guard of
Я
Ukraine.
хотів би почати
I would like to
перед тим,
start
як безпосередньо
before
перейти
I
до
move
проблем
directly
СОФу,
to the problem of terms
йшлося про
when we talked about
формування
development
порядку вашої
of
конференції. Я
agenda of your
року
conference.
приймаю в ній участь.
Every year I
Дякую
participate.
за
I'm grateful for the
за
invitation.
запрошення. Раїса Федорівна,
Раїса Федорівна,
скиньте тему,
could you send the
тему. І на той
topic?
час ми
And at
завершували
that
там
time,
проект,
we're finalizing a
який, я
project,
думаю, ми
which in
зможемо,
my view can be
представити,
shared
презентувати на
and
коронних
presented
читаннях 9
at
жовтня.
one of readings
Сьогодні
on
вже
October
робота
9.
над ним завершена
Today the work
і
is completed
передано
and
до видавництва.
it is transferred
І
to the
якраз,
publishing house.
в той момент я працював
At
над
that point of
главою
time, I was working on the
процедурному
chapter on
податковому
terms in the
праві, і
procedural
сказав,
tax law.
давайте я
And I'm
зупинюсь на
saying,
тому.
Reese, let me discuss
Після
the
цього
terms.
мені прилітало ще
After
декілька
that, I
дуже
received
цікавих
several
пропозицій.
other interesting
Одна із них
problems.
це
One of
проблема
them is the
території.
problem of territory.
Я лише так на правах реклами, може хтось
Just as an
підхопить
advertisement,
і
maybe someone will
буде
catch it up and
доречно йому
it will be feasible for
це
them
буде доречно йому це в подальших своїх
to develop this
дослідженнях.
in their research.
Справа в тому, що
The
взагалі
point is that the criteria of territory in the tax regulation before the war was linked. It is the problem of residency, where the person is staying for more than half a year. It's the problem of competency when general national taxes in all territory of Ukraine, local taxes and duties in the territory of local communities. And the problem of free economic areas, very carefully, but it is what we faced, and the war starts after that, and at the moment, indeed, the problem of residency is totally different, taking into account IDPs, taking into account persons temporarily left Ukraine, hopefully temporarily, and other things. Can tax liability be the same for the individuals who are staying in occupied territories, in the territories where active hostilities are conducted, gray area, and territory controlled by Ukraine? Of course not. And this criteria of territory, conditionally, theoretically, the problem gains the practical significance, and I'm very grateful to the judges of the Cassation Administrative Court, because Raisa Fedorivna emphasized this, that we cannot have the same approach to defining the tax liability for the individual who fulfills tax liability in the gray area. It was a case of a Volchansk district. And we're grateful to Uzhgorod, Ivano-Frankivsk, and so on, and the taxpayers who fulfill liabilities in the controlled areas and relatively, quote-unquote, quiet areas of Ukraine. When we reformatted the traditional construct, we have to take into account this, taking into account current circumstances. The same is true about the terms. First, the terms, why are they important? When we have analyzed the subject of financial law, this is what we studied. When the individual is answering to me that this is public funds, yes, it's already grade C, but why is it grade C? Because I believe it is of principal importance that we need to have at least one word, the flow of public funds. Public funds cash flow. Imagine the situation when the taxpayer fulfilled tax liability and paid all taxes to every penny on the 31st of December of the current year. That is, they fulfilled the tax liabilities to the state, but not on the monthly basis, not on the decade basis, as it is established by the law, as it is established by the tax period. Can the state exist in this situation? Of course not, because the tax revenues are used for monthly social benefits, financing of this government functions. That's why the problem of terms, of fulfillment of tax liability, adhering to the stages of these terms, in my view, is one of the key and most important. And once again, I'd like to introduce the idea: the tax law, is it a substantive law or procedural law? Because no substantive provision, no substantive norm cannot be implemented without appropriate procedure. And this is what we discuss in our publication, in which we will be able to present on October 9. Next point, as regards the deadlines, as regards the terms, in this case, can we find in the tax regulation more comprehensive idea, more comprehensive category? And comprehensive not in the sense of legal regulation, but in the sense of combining scholastic views. In this case, the terms are also the time periods, which are traditional and it's not always established by the law, like seconds and minutes and day and month and year and so on. And also, in this sense, we have to fine-tune this general, known, conceptual understanding of the terms to adjust this to the circumstances related to some legal consequences. In this sense, we talk about evaluation and definition of dynamics of actions of tax legal norms, application of capacity of bringing to liability, enforcement. In this sense, when we evaluate comprehensively the construct of terms, of timeline, and the tax regulation, it's about applying traditional time criteria: day, month, quarter, the purpose, the terms as the grounds for implementation of rights and duties by the entities, as well as powers. At what point of time do I have some liability? When does it appear? Identifying the consequences for violating the terms. And in my view, it's not discussed very actively at this point. I haven't seen this emphasis. It is some limiting factor. Limiting in the sense of ensuring, in the sense of prevention of arbitrariness of controlling agencies. This is also terms, it is related to terms, to time limits. What is the peculiarity of tax regulation and terms and tax regulation? First of all, formal definition. In this case, we're based on specifying the gender sign of the law based on the tax conditions of regulation. That is, the nature of tax terms is linked with the appearance, change, suspension of tax liability overall, and its components. Special assessments. In this case, it's not about specific time term. It's also about objective of assessments, this term of time. In the first case, when we characterize or review terms as some task, it's about what should be done, to perform accounting, to pay, and so on. In the second case, when we review the terms as some summary, based on which we do conclusion on how to evaluate everything that happened before this, how the taxpayer fulfills their liabilities. There's also some reporting components in the term.
Облікова періодичність.
The accounting
Тобто, в
periodicity.
даному випадку
In this
період,
case, the
строк
period, the
передбачає
term,
не абстрактну
envisages
вимогу
not some
чи
abstract
вказівку,
requirement
а
or indication,
деталізацію того, що
but
треба
details
зробити. І
instruction of what should be done.
значення
And the
висновку.
consequence, the effects, the
Тобто,
conclusion.
особа діяла
The
відповідно до
individual acted
законодавства,
according to
або особа
legislation
порушила
or
норму
individual
законодавства.
violated
Причому, на
the
мій
provision of
погляд, в
legislation.
даному
In my view, in
випадку
this
і в
case,
першому, і в
in the first and
другому
in the second
обставинах робиться один із
circumstances,
висновок.
the same conclusion is
Треба
made
застосовувати, є
whether
підстави застосовувати
we need to apply, whether we
запобіжний
have
та
grounds to
несприятливі
apply
наслідки, чи
sanctions
немає
against the
таких
taxpayer or no grounds.
Ще на одну особливість
One
саме
more
податкового
peculiarity of the
сенсу строків я хотів би звернути
tax
увагу.
meaning of the terms that I'd like to
Правові
emphasize.
наслідки
The legal
течії строку
effects
і
of
розрахунку строку.
duration of
Якщо в
term and
першому
calculation of term.
випадку
In the
йдеться
first
про
case, we talk
об'єктивний
about
процес,
objective process,
незалежний від поведінки
which does not
учасників
depend on the behavior of
відносин, то
participants of relations.
розрахунок
Then
строку
calculation
якраз
of
і
term
передбачає їх
envisages
безпосередню участь.
direct
І в цій
involvement of
ситуації
participants.
якраз
In
і
this
можуть
situation,
бути певні,
there may be some
певне непорозуміння
misunderstanding
конфлікт
or the
розуміння
conflicts of
контролюючого
understanding
органу
of
при
controlling
розрахунку
agency when
та
calculating the term
безпосередньо
and the
платника
taxpayer
податку при такому розрахунку.
when this calculation is made.
Строки давності.
The statute of limitation, one of the most important aspects
природи, характеру,
in identifying the nature and character of terms.
з строками давності ми
The statute of
маємо
limitation
пов'язувати
is
настання тих чи інших наслідків
linked
для платника.
to
І в цьому
consequences for
сенсі
taxpayer.
ми можемо
In this sense,
маємо виділити
we have to outline several types of statute of limitations. The terms of bringing to responsibility. Article 102 of the tax code, I will not discuss it in detail, it's clear. The statute of limitation when implementing the enforcement of the tax liability, the statute of limitations for appeal against the decisions of control agencies in the courts. This is directly linked to your expertise and your experience. And it is 3 months or 6 months. And once again, I'd like to refer to my time is running out. I'd like to refer to the interdisciplinary conflict of legal provisions, the comprehensive understanding of the statute of limitations. It's about the situation when the claim is filed to the court, when filing the claim to the court. And before that, there was the procedure of administrative appeal, and the taxpayer has to appeal decision in the court, decision of the controlling agency during 1 month, which follows the day of the end of the procedure of administrative appeal. In this situation, the Supreme Court and me, I'm joining this opinion. It is based on the priority of special provisions of the tax code of Ukraine, which identifies the procedure of court review of the tax notifications and decisions and decisions of other controlling agencies on accruing liabilities under the condition of previous application of a pre-court procedure. Here, once again, as a final remark, I'd like to mention the last year of warren of readings when we tried to find the common denominator between administrative procedure and tax procedure. And in my view, the law on administrative procedure requires certain refinement and explanation in this conflict. So the conflict between the procedural regulation, what's going on according to Chapter 2 of the tax code, and the procedural regulation, what's going on under provisions of the law on administrative procedure. Thank you. I fit my 15 minutes.
Щиро дякуємо вам
Thank you very
і за
much
це, звісно, але
for this as well,
насамперед
but
за
first of all,
ґрунтовний
thank you
комплексний
for
аналіз приводу
comprehensive
практики
analysis
спосіб,
of the nature and
який
character of
вами
terms,
заснований на основі
which you
практичного
founded on the basis of
правозастосування.
practical
І спадає
enforcement.
на думку одразу
And immediately I have the idea about the expression by Chebyshev that the theory without practice is dead and fruitless, just like practice without theory is useless and detrimental. To present our next speaker, I'd like to pass the floor to my co-moderator, dear Igor Yaroslavovich. Please, Igor. Microphone, please.
Мікрофон.
Даруйте. Ще раз доброго ранку.
Good morning once again. Good afternoon to all participants in the conference, to the presenters. Ms. Irina, thank you. Passing the floor.
Thank you for giving me the floor in such a nice way. I want to comment what the previous presenter said. It causes us more profound consideration regarding practical application. My colleague not only disclosed the topic quite well, but gave way to further study. I want to present our next speaker, Oleg Zavirucha, Deputy Head of the 8th Administrative Court of Appeal. He's Doctor of Law. He represents the generation of Ukrainian judges and scholars that formed administrative law system according to European standards. He went the way from judge assistant to such high position, demonstrates the process of advancement of court system after the reform. It pays great attention to international cooperation and using European approach to justice. The topic is balance of private and public interest of participants in tax relations under martial law. Oleg, the floor is yours. Thank you, Igor Yaroslavovich, for such introduction. I want to emphasize that, of course, all these things are nice and one wants to implement them in cooperation with the Constitutional Court. I welcome you all, and I want to express words of gratitude to organizers of the conference. Thank you for invitation, and thank you for the possibility to make this presentation. Using this opportunity, I want to express words of solidarity and support to all judges of Ukraine and staff members, despite dramatic realities of current situation. We all continue to administer justice at high level. As regards topic of my presentation, Ukraine is resisting full-fledged armed aggression for the 5th year running. Ukraine faces the challenge regarding functioning of financial system of the state, and that exceeds the limits of pure economic topics. It acquires strategic meanings because we mean ensuring state security, defense capability, and resilience of state institutions. Therefore, search for optimal balance between needs of the state to get financial revenues and to ensure rights and guarantee interests of taxpayers. This is one of the biggest challenges for modern administrative justice. A few theoretical words In tax law, interest is the basis for tax compromise and essential limit of this compromise. Interest is demonstrated in desire of parties to meet their needs by making lawful actions, protecting their rights to get material and other benefits, and fulfilling duties imposed by tax legislation. Interest of taxpayers and the state, these are the components of interest. The main idea of this compromise is regulation of relation between these interests, private and public interests. In taxation relation, conflict of interest arises between private and public interest. Traditionally, public interest is connected with the general well-being of society. Public interest is associated with interests of the state and territorial community. Private interest is more connected with individual needs or individual taxpayers. And although traditionally state interest is one of the main in taxation, it is important to separate interest of the state as a mechanism governing society and interest of society that must be defining in this interest. That will help us to ensure a balance and meet the needs of all the parties in taxation. In condition of peaceful time in democratic society, public and private interest as a rule are in relevant balance because regulation is aimed at achieving proper balance between fiscal needs of the state and safeguards of rights of taxpayers on the other side. That is explained by the fact that in such society, principle of rule of law is abided, and human rights is the value for all members. Ensuring the proper balance of private and public interest must be based on such key issues. First, achieving state interest cannot be the final goal for legal regulation of tax relations. Second, the main objective of taxation is in agreeing public societal interest and formation, balancing and societal proportions. Third, the need to ensure interrelations and interaction between different interests to ensure well-balanced and fair taxation that will facilitate general well-being of society. However, realities of peaceful and war times make correctives into balance of interest. One should state that introduction of martial law became an objective factor of rethinking these relations between public and private interests. In conditions of armed aggression, public interest is enhanced. Proper revenues to the budget are of critical importance for financing defense and functioning state authorities and maintaining economic resilience of our state. One should mention that enhancement of public interest in condition of martial law is an objective consequence of change of priority. At the same time, this transformation doesn't mean loss of the importance of private interest, but only stimulates the need of search for new proportional balance, needs of the state, and safeguards of taxpayer rights. Tax regulation in wartime is of special importance. It fulfills two important functions: fiscal, to ensure stable revenues to the budget, and regulatory, creating conditions for sustaining economic activity of economic agents. Armed aggression of Russian Federation against Ukraine caused a number of economic disbalances. I mentioned few of them. Loss of part of tax base because of close down of enterprise and migration of people. reduction of investment, break of chains of communication. That requires flexible adaptation of tax system and regulation to new challenges. Under such circumstances, tax law acquires not only fiscal, stabilizing nature, it has mobilizational one as a result of tax compromise, shifting focus to state or public interest. However, during the martial law, principle of rule of law does not lose and cannot lose its meaning. So discretional or unproportional limitation of rights of taxpayers are not allowed. Since the introduction of martial law, the state used a number of urgent measures aimed at sustaining economic activity and minimizing administrative burden on business. Simplification of procedures of tax administration, introduction of benefits from small and medium-sized business, postponement of some obligations and moratorium for conducting checks. That was aimed to reduce possible bankruptcy and sustain economic activity even in crisis conditions. Another important component, martial law actualizes the issue of proper administration of tax relations, transparency of decisions of tax bodies, preventions of abuse of discretional powers, and ensuring effective judicial control. As regards the latter, I want to focus more attention. In conditions of martial law, administrative justice courts get the duty to ensure a real balance between public and private interests, while implementing functional control over power agents in conditions of martial law. Judicial case law gets special importance. It not only resolves certain disputes, but shapes uniform standards of application legislation, defines criteria of interference of state in the sphere of private rights, and defines limits of implementation of discretional powers. Balance of public and private interest gets practical interest through judicial procedure. Special role in such approaches belong to Cassation Administrative Court within Supreme Court, whose legal positions ensure uniformity of legal practice, define standards of judicial control over activity of tax authority, and serve a landmark for other instances courts in tax disputes. Analysis of group of administrative cases shows that disputes connected with administration of taxes and duties traditionally and in a stable way belong to the biggest number of cases that are caused by complexity and dynamic nature of legislation and high intensity of implementation of administrational functions in taxation. 8th Administrative Court is working efficiently, and the figures are on the slide. They confirm the above statement. Statistical data show that each 8th case that comes to 8th Administrative Court within this year, and each 7th case considered in the entire mass was pertaining to tax relations. This statistic shows that tax disputes has great impact on the structure of courts' work burden. Implementation of tax policy is of great importance. In conclusion, I will come back to the topic of my presentation and formulate a question. How to ensure a balance between public and private interests in conditions when the state objectively requires broadening instruments of protection of public interest, but cannot allow limitation of rights of taxpayers? The answer is within three major elements. First, qualitative legislative regulation. Second, proper management. And third, effective judicial control. This balance of interest in conditions of law is a dynamic category that is shaped under objective factors and the need to ensure basic rights of taxpayers. It should be implemented through legally certain norms of tax regulation based on the principles of rule of law, legal certainty, and proper governance. So we continue working, effectively realizing tasks of administrative justice, serving the rule of law. Thank you for your attention. Oleg, thank you for your interesting presentation. The topic is quite significant. In conditions of martial law, the state is forced to ensure proper revenues to the budget to finance defense, but safeguard rights of taxpayers. That requires search for the proper balance between public interest, ensure fiscal stability and protection property rights, legal certainty, fair taxation. I want to emphasize that this presentation has academic importance. One should analyze changes to legislation, judicial practice. It forces us to start thinking about criteria of achieving such balance. So thank you very much again. Irina, the floor is yours. You will present next speaker. Thank you, Igor. Oksana Muzyka-Stefanchuk represents ADE School of Law, Kyiv, Taras Shevchenko National University, Professor, Doctor of Law, Head of the Department of Law of Kyiv, Taras Shevchenko University. She is also working in the National Academy of Legal Sciences of Ukraine, member of Scientific and Advisory Board of Supreme Court. She got a number of awards. She represents a new generation of leaders of Ukrainian science. She defended her doctor's thesis when she was only 31. So she covers not only public finances, she got qualification in public administration and healthcare. She will speak about boundaries of branches of law and legislation, using the example of public finance law. Please, the floor is yours. Good afternoon, colleagues. Thank you for introduction. It's unique. Me, myself, are inspired by hearing how many positions and borders I have. I want to take part in the discussion of this conference that allows us to express our thoughts and to discuss the topic with participation of different institutions and offer the ways of resolving the problems. What I most like in this conference devoted to public finance and public finance law that we are developing gradually and switch from economic into legal sphere. Public finance was perceived as economic category traditionally and studied as academic subject. But taking into account European experience, we have grounds to believe that there is public finance law, and having public finance law in conditions of war. My topic covers boundaries of branches of law and legislation.
I would like to discuss some aspects that are not doctrinal, because our roundtable have leading scholars and practitioners and professionals in theory and researchers from different areas. I'd like to outline some practical aspects which are concerning for us and which have practical significance. Different areas of law, different areas of legislation, this is obvious, and we will not contradict anything in this regard. But there are some points related to financial relations, public financial relations in the context of legislation, because sometimes it is hard to understand what is understood by the legislator and enforcer when they talk about financial legislation. If we look at the practice, the jurisprudence of the Constitutional Court, at the official website, we can find the list of areas of law. Although mostly this list is used for convenience to systematize legal positions of the Constitutional Court. The list of areas of law of the Constitutional Court outlines administrative law, administrative procedural law, electoral law, commercial law. Maybe there will be some changes, commercial procedural law, environmental law, constitutional, land, housing, criminal procedural, customs, family, and financial law, which covers the banking, the budget, and taxation. As regards banking, we have some issues because banking relations are existing on the crossroads of public and private regulation. When there is banking regulation, when there is impact of the national bank, interaction between national bank and commercial banks, we can talk about public relations, about governing impacts. When the bank relations are between banks and the clients, this is 100% private relationships, and in the context of area of financial law, we cannot talk about this. It will be civil relations, but in the classifier of the areas of law of the Constitutional Court, we can see this in the limits of the financial law. In the past, the Ministry of Justice approved the classifier of the areas of legislation, and in this classifier, they recorded that it is established to ensure enforcement of tasks, to have the database of legal information necessary to form legal policy, has sufficiency of legal regulation, and so on. This order was in 2004 without making changes, which makes us think that the act is effective, but it's not working because for 22 years other laws and regulations were adopted, other relations appeared in the area of public procurement, public-private partnership, some international humanitarian relationships and so on. There are changes. And in this classifier, there is a list of areas of legislation which is very wide, unlike what is suggested by the Constitutional Court. If we compare the list of areas of legislation of the Constitutional Court and the list of areas of law, the list of areas of law and the list of areas of legislation according to Constitutional Court and the Ministry of Justice, there are some discrepancies. It's obvious. And here we have the issue arising very often if we go back to 10 years ago and if we remember other students, we can remember how we were taught about areas of law and areas of legislation, sexual legislation. Every area of law has its sexual legislation. At the level of the Ministry of Justice and Constitutional Court, we don't see homogeneous position, don't see understanding of what is financial legislation. Then the issue arises, what should be students taught when they answer the question of what is financial legislation? Our starting point should be only doctrinal generalized positions, holding to the public legal nature of financial legal relations. If I say that financial law is public law. In the classifier of areas of legislation, which I mentioned according to the Ministry of Justice, there is no financial legislation at all. Instead, they have the area of legislation as finance and lending. It seems to be similar, but these areas are very different. If we look at the basis of private and public law, if we talk about public legal regulation, general provisions, the financial system, basis of budget process, system of taxation, everything is part of this classifier of the Ministry of Justice. General public expenditures and expenditures of local governments, effects regulation, debt, and so on. Then there is mixed public legal regulation, which I mentioned before. So, if we talk about proportionality of development of the areas of legislation, we need first of all at the sub-law regulation level, we need to identify the areas of law and areas of legislation, which in Ukraine is non-existent. If areas of law, in theory, can be delineated in the textbooks, we can write about this. The areas of legislation are practical manifestation of the areas of law, or what creates the foundation for creating the areas of law. And until we have updated classifier of areas of law, of areas of legislation, we'll have this misunderstanding. And how this misunderstanding is reflected in the case law of the Supreme Court. For example, I like that the Supreme Court, the Cassation Administrative Court, is very close to us as financiers. It is the institution which suggested for our professional lexicon, and we use it going forward. It is the term public financial policy. What is public financial policy? Can we say that it is related to and it produces financial legislation? Not exactly, because financial legislation, as we see, is very diverse in terms of definition in our sub-laws. What is it? How to link public financial policy and financial legislation? Public, private, the nation is non-existent. Overall, I will not take too much time of our distinguished moderators and participants. I would like to, at the end, to suggest or to emphasize once again that the Supreme Court and the Constitutional Court and the Ministry of Justice It would be very positive if they reflect in their activity, if they could find common denominator in definition of the areas of legislation. Among us, we don't have participants as representatives of the Ministry of Justice, but we can continue this discussion as another platform. This issue is very urgent. I would like to wish all of us productive work and our soon victory. Glory to Ukraine, and thank you for your
Героям
attention.
слава, пане
Glory to
Георгію.
heroes,
Дуже,
Oksana.
дуже вам дякуємо за підняття
Thank you very much
такого
indeed for
активного,
raising
актуального
this
питання.
important
Насправді, воно
topic.
виникало ще
Actually,
у період мого
it emerged in the
студентства, і
period when
ми,
I was a student,
тоді
and
ще на етапі
at that
формування,
time, at the stage of development,
батьками-засновниками фінансового, податкового
by the
права
founding
сучасної
fathers
України,
of financial and
вже
tax law
стикалися
of
з
modern
тим,
Ukraine,
що не
we
відповідають,
faced the situation that the
законодавчим
areas of
вимогам
legislation
чи
are not the
сферах
same as the
теоретичного,
areas of
скажімо так,
law.
розробки. Проте на сьогоднішній день воно
However,
все ще
at the
залишається
moment, it is
нерегульованим. І
still
тому вам велика
unregulated,
подяка за
and
те, що ви
thank you very
його
much for
ініціюєте і
initiating
просуваєте,
this
бо
and
всі ми є
promoting this,
і
because
викладачами, як ви
we're all
правильно сказали, що
teachers,
таке
as you rightly
викладати
mentioned,
студентам.
what to teach
І
to
ми є
students in
всі
this case, and we're all
правозастосувачами. Тому
enforcers.
без того, щоб
So
наблизити
without
в
approximation
реальному житті і на
in real
практиці
life and in
цих дві
practice
категорії,
of these two
не вийде
categories,
об'єднати
we
цих
cannot
дві
unite
сфери.
these two areas.
І не можу говорити вічно, маю таку
I
честь
cannot
передати
speak
слово
eternally.
пану
I'm honored to
Ігорю.
pass the floor to Mr. Igor, please.
Пане Ірино, дякую.
Ms. Irina, thank you. And we move to the next item of our agenda. Our next speaker, I'm pleased to introduce our next speaker, Mr. Vasil Ilkov. Is the judge of Dnipropetrovsk District Administrative Court, the Doctor of Legal Sciences, Professor, LLM. He is one of the representatives of Ukrainian legal community who actively works on integration of digital technologies in the area of justice, which is very progressive. His professional experience covers all the range of activity of judiciary, from working in the staff of the court to performing justice and scholar activity. Special attention is dedicated to the issues of digitalization of justice using artificial intelligence and adaptation of legal mechanisms to the conditions of crisis management. The topic of his presentation is very interesting. It is application of algorithms of AI in enforcement on VAT in the conditions of war. Mr. Vasil, the floor is yours. Good morning, dear colleagues. Thank you very much for this opportunity to participate in this important event. It is a great honor for me as a first instance judge. It's a great tradition indeed. During the days of administrative justice, every year, to hold an international conference to gather together leading local and international scholars, researchers, practitioners to discuss the most urgent and important issues of enforcement, development of administrative justice, administrative system. It is very important, especially under the conditions of war, under the conditions of martial law. I'd like to thank Igor Vladimirovich, the chairperson of Administrative Court, for supporting this tradition. Ms. Seferin is a methodologist in implementation of tax relations. Natalia Evgenievna Balshevska, who deals with organization and also organization of AI. In the process, all moderators and judges who are involved pay a lot of time, dedicate a lot of time to implementing these problems. Dear colleagues, I selected quite an interesting topic, which can help us to resolve certain issues of enforcement which we face during enforcement practice and the conditions of martial law. Once again, using AI algorithms. The topic I selected is related to VAT. It is unusual practice, and it is comprehensive matter. We all know that since the beginning of martial law, since the introduction of martial law, the moratorium for inspections was introduced. Traditional instruments of tax control became limited, and of course, some algorithms were introduced. Everything started back in 2019, but some technological use started, and it led to the situation when we received full automation of the control over the movement of goods in the chain and other peculiarities. How AI works in this case? We all understand some peculiarities of implementation. If we discuss the use of suspension of tax receipts, last year more than 500,000 of tax receipts were suspended automatically. The state tax service using AI algorithms and using the AI technologies, in this case, without involvement of individuals. Some technologies were applied which have consequences for further destiny of individuals and legal entities, which are taxpayers. Once again, what is the peculiarity of implementation under the conditions of martial law? We have the trend to increase some risky transactions, and there are some new and not so new, some modified schemes of tax evasion or VAT evasion. Fictitious transactions, some specificities of frontline regions. We have more of those. If I can collect some statistics, temporarily occupied territories. There are some peculiarities there, and the algorithm is effective. It is triggered. If 1 million is suspended, how much was processed? It is millions. It is the sign that this is huge database. This is huge amount of information processed by the algorithms. This information is processed using some algorithm. How is it used and processed? Once again, this is not quite clear. How does it work? How was it implemented? How does the system of monitoring of risky transactions work? In terms of general understanding, it uses the machine learning models for automated analysis of tax receipts. What is machine learning model? There is a database somewhere which accumulates and stores information. There is powerful software, there's powerful hardware processing all this, and there is software and some sequence and some codes which gives the specificity of implementation and specificity based on the results of machine learning. The algorithm works and selects certain tax receipts, and the algorithm compares the taxpayer behavior with the typical patterns and identifies the risk level. how the algorithm identifies the risk level. We don't understand because we don't see the algorithm, we don't see this code. There is a small presentation here of the algorithm itself, data analysis, automated inspection, blocking of the risky transactions is made, and the risk criteria are adapted to the martial law. This is another additional indicator which is introduced. The issue arises as a first instance judge, how the first instance judge can respond or properly examine circumstances in the court session, not understanding the algorithm, how the use of artificial intelligence may have the impact. Dear colleagues, let me move away from the standards. I'd like to ask a question to colleagues. Have you encountered, when doing administrative justice, have you encountered any cases of AI algorithm used during the review of tax or disputes? And how were they implemented? Colleagues, 1 minute, would you like to share your experience? As a moderator, I can answer immediately no. I did not have those cases personally. What is suitable to a question is, now there are many participants who use algorithms to draft the procedural documents, but no one relies on this as the instrument. It's for enforcement, for use in determining some violations, some liabilities. We did not have this. Thank you. There are hands raised in the audience. Please.
Шановний Василю Васильовичу,
Dear Vasil Vasilovich, our discussion is scheduled after the last presentation of this session. Maybe we can postpone the exchange of opinions for the time allocated in the agenda. Thank you. Thank you, Irina Leontievna. In that case, maybe in the chat you can write additional questions, and then please send your questions in the chat or ask your questions during the allocated time. At the end, I'll be happy to get involved. All right. Thank you, Yuri. More and more often in the court hearings, we see that some documents were generated using some AI algorithms. How can you see this? It is the structure, it is the conclusions, it is errors that can happen, it is the logic. Technologies are developing, technologies are evolving. What are legal problems of using AI? Erroneous blockages. The algorithms block good faith taxpayers because of false signals, stopping registration of tax receipts and inhibiting the business. Some developed information, some database which is transferred can distort information, and as a result, the tax receipt is blocked. Insufficient motivation is reflected in many positions of the Supreme Court. Automated decisions often do not contain justification, and it's impossible to challenge them, and this violates the principle of legal certainty. And the judge themselves, they don't understand the logic. First, they don't have the access to the system. Second, they don't understand the code and the criteria for identifying the risk level of the transaction. The representative don't understand this. If we ask the inspectors and others, they don't understand this. It's impossible to establish this, because they say everything is done automatically. It's the question to those who developed the appropriate algorithm, and then it was just implemented. And we can say directly, it's hard to ask about further implementation. judiciary disputes, the number of cases is rising. More than 1 million blocked VAT receipts that were blocked. This is potential matter for disputes. Personal data protection is a separate problem. It is the problem, a separate presentation. Once again, the principle of GDPR directive, European directive GDPR, the law of Ukraine, and personal data protection.
Дуже багато обставин, які вимагають доопрацювання. Шляхи вдосконалення.
How to improve that?
Впровадження пояснювального штучного інтелекту.
Implementation of explanatory artificial intelligence that helps to understand the logic. Very simple algorithm, a bot, based on AI algorithm that could tell the logic of adoption of the decision.
Прозорість, те, що я також згадував.
Transparency. We must understand that court should be given access to understanding of the logic of decisioning, publication of criteria of risk, methodology of assessment, implementation of such a thing, for instance, adaptation of legislation to legislation of European Union. The highest risk of tax relation when algorithm AI is used. The highest, what are the highest risks? Legislative changes. In tax code of Ukraine, it should include procedure for appealing the decision, safeguard for taxpayers. Only after you fix it. In fact, we do not have the regulation of artificial intellect. The issue of responsibility. The body that makes decision.
Ну і, шановні колеги, дозвольте тоді перейти до висновків.
And then I come
Штучний
to
інтелект
conclusions.
підвищує ефективність податкового контролю в умовах обмеженого доступу до традиційних
In conditions of limitation of access of traditional checkups,
тих
that happens
встановлення, з'ясування обставин, які
for determining circumstances that stop the invoice. But as you know, there are many complaints. That is the biggest category of case. You need integral regulation of algorithm in tax sphere. Although at the level bylaw, regulatory act, it would be nice to do it. Explanation of decision taken. In all cases, neither one party nor the other party cannot explain in full. So to realize the principle of explanatory nature of decision and balance between effectiveness of control and safeguard of rights of taxpayers. Such great number of invoices cannot be stopped automatically without proper legal substantiation. At the same time, we must realize the development of technologies causes automation and computerization of all spheres of life. Tax control, in this case, probably takes the most significant place. And the computerization, the digitalization of justice is possible and is unavoidable. And as you mentioned before, in perspective development
враховувати
in the
положення
future to
Європейського
take into account
законодавства,
provisions of
прийнятого
European
так
legislation
імплементованого актового акту, безперечно,
that had been
це буде
adopted and
наголошати на
codified, that
Так,
will be the
шановні
direction for further changes. Dear colleagues,
дякую за увагу.
thank you for your attention. Glory
Я
to
намагався
Ukraine.
вкластися в 17
I
хвилин.
tried to fit
Шановні,
in
якщо є час,
17
то я
minutes.
з радістю
So
відповім
if I
на
have
які
more
є, для того,
time
щоб не
left, I will be
переривати
glad
тематику
to
і
answer
руху
questions,
безпосередньо
not
нашої
to
тематики.
interrupt this
Щиро дякую.
topic and the rationale of this topic. Thank you indeed. Thank you, Vasil Vasilievich, for quite up-to-date and valuable presentation. As Irina mentioned, discussion will be in the end of presentations. And who is interested, and I'm sure that many people are interested in it, we shall discuss it. So your presentation was quite useful. Algorithms of AI, this is something new and interesting for us, especially VAT administration in conditions of martial law. One should mention that such things are important because promptness, transparency in such decisions is important, and that will help to ensure a balance between effectiveness of tax control and protection of rights of taxpayers. And for definition of legal boundaries of use of AI in court procedure, in the analysis of risks, benefits and advantages. This is also significant and consideration in order to use new approaches. Thank you. Now, Irina, you will introduce the next speaker.
Щиро дякую, пане Ігоре.
Thank you,
Я
Igor.
хочу з особливою приємністю представити
It's my
нашу
special
наступну
pleasure to
доповідачку.
introduce
Це
our
наша
next speaker,
колега Олена Анатоліївна Губська.
Olega
Вона не лише
Gubska
професорка, доктор
is our
юридичних
colleague.
наук,
She's not only a
нагороджена
professor and
багатьма
doctor of law.
грамотами та
She was
відкриттями
awarded with
наукових.
many
Вона насамперед для нас колега і
certificates
суддя.
and
Олена
awards.
Анатоліївна
But
має
for us,
багатовічний
first of all, she is a
досвід роботи на
colleague
всіх
and
рівнях
a
судової
judge
влади
with
України.
many
Від
years'
суду
experience
першої
at different
інстанції до
levels, from
судді
first
Верховного
instance
складу
court
Верховного
up
суду.
to
Вона брала
judge of
активну
Grand
участь у
Chamber of
підготовці
Supreme Court.
суддівського корпусу
She's
в межах
taken
програм,
part in
розроблених Національною
training
школою суддів.
judges
Вона
in the
і
National
експерт, і
School of
тренер,
Judges.
і розробник
She is
освітніх
both
програм.
expert,
Зосереджує
trainer,
свою
and
увагу на
developer of
найбільш складних
educational
категоріях
program.
публічно-правової
Focuses
юстиції.
attention at
Її
most
наукові
difficult
дослідження присвячені проблематиці
aspects of
захисту прав
dispute.
людини у
Her
відносинах між
academic
особою і
work
державою в умовах
is
сучасних
relations
глобальних
between
викликів.
state
Пані
and
Олено,
human being
сьогодні ви
in
торкнетеся
global
проблем з питання
challenges.
плати за землю,
Lena,
тож я
you will
найвідважаю
discuss
вас від
problems
вашої
of payment for
Прошу.
land. So please, floor is yours.
Добрий день, шановні колеги.
Good
Дуже
afternoon, dear colleagues.
Яскравий, можна сказати, виступ Ірини Леонтівни. Дуже дякую.
Irina, you made
Я
such a
дуже
bright
рада вас
introduction
бачити,
of
чути, тому що
myself.
це
Thank you
велика
indeed.
честь взяти
I'm very
участь у
glad
такій
to see you all.
фаховій
It's a great honor
дискусії
to take part in such
щодо
professional
проблемних
discussion,
питання.
to
І
hear
я
about
погоджуюсь
problemic
з тим,
issues.
виступав пан Ільков, і він говорив про те,
Mr.
що
Ilkov
це дуже
spoke
правильно, що ми
before,
зустрічаємося.
and
Ну,
he
вирвань
emphasized how
різний,
important
але
is that we are meeting and
в
discussing.
межах
Bad is that we are meeting only once a
святкування
year,
таких днів адміністративної
but
юстиції ми
when
можемо побачити один одного і
celebrating
обговорити
our
ці
professional
питання.
holiday, days of administrative
І
justice, it
дійсно
is
хочу
especially
сказати,
important.
що публічні
I must say that
фінанси і
public
правозастосування в питаннях
finances
публічних фінансів
and
дійсно
law
дуже актуально,
enforcement in public
особливо в
finance
умовах
is very
війни,
significant, especially under
умовах воєнних
conditions of
станів,
war,
тому що
martial law.
саме тут відбуваються зміни як застосування
It's
спеціального
here that
податкового
changes
законодавства,
of
зараз
legislation are
в даному
happening,
випадку
benefits are
зміни у
introduced,
податкових зобов'язань,
changes are made to
Крім того,
different tax
саме в
commitments.
цьому моменті і в
Besides,
саме воєнного часу
in the
вносяться
period of
зміни до
war,
пріоритетності видатків,
changes are
тому
made
що першочергово
in order
ведеться
to
фінансування
prioritize
потреб
taxes
сектору
because
безпеки, оборони,
the
соціальної
need
сфери.
of financing
Крім того, посилюється
defense
контроль
is
за
growing.
коштами
Social sphere also
міжнародного
needs
валютного
revenues.
фонду і бюджетних коштів.
Both international
Хотіла звернути
assistance is
увагу,
coming and
що
budgetary
вносяться
revenues are
зміни
needed.
до податкової
Changes are
політики, в
made
тому числі
into
і щодо
tax
земельних
benefit
повноважень,
system
земельного
as
податку.
regards land tax.
Наприклад, були
For
внесені зміни
instance,
до
changes were
розділу
made
10, розділу
in
10
Chapter
Податкового кодексу, де було
10 and
зазначено, що
20 of
земельна
Tax
плата
Code,
і орендна плата за землі
land
комунальної та
fee,
державної
rent
власності
fee
не нараховуються на
is
ті
not
землі, які
accounted on the
знаходяться
lands
на територіях
that are
активних бойових
located
дій
on the
та
territory of
ті землі,
active
які були
hostilities
тимчасово
and
окуповані.
land that were
І
temporarily
безпосередньо, відповідно,
occupied.
міністерство затверджує перелік
And the
територій, де
minister
відбуваються
approves
бойові дії,
the list of
і там,
such
де не
territories where
сплачуються такі податки.
hostilities are taking place and
Крім
such
того,
taxes are not
зазначено,
paid.
що не сплачуються податки за
And
землю
it is
на
mentioned
тих
that
територіях,
land
які
tax is
забруднені,
not
ну,
paid
наприклад,
at
забруднені
territories
рукожіпами,
contaminated
боєприпасами,
with
як відбувалося
explosives,
мінування.
ammunitions,
І
or had
там,
been
де
mined,
зруйновано майно, але таке майно
where
мало бути
property is
внесено в
ruined,
реєстр пошкодженого
and
або
that
знищеного
ruined
майна, але
property
такі
should
щодо майна
enter
повинні
into
бути
the
внесені відповідні
register
зміни.
of laws,
Крім
and
того,
changes
не
to
сплачується
be made.
мінімальне податкове зобов'язання.
Plus to that, minimum
Хотіла б
tax
також зазначити,
obligations are not
що
paid.
щодо
I also want to
можна говорити
mention
не тільки в даному випадку про земельний
that
податок і орендну плату,
you should discuss not only land tax and land rent, but also this minimum tax obligation that was introduced even before the war in 2021. It was included into tax code. One should mention that this minimal tax obligation is paid by users and owners of agricultural lands. They pay this minimum fee into the budget. But during hostilities, changes happened and some lands could not be used for agricultural purposes anymore, or are not used for growing certain crops and sale of it, but only growing some crops for your own use, your household use. The question arises where you should pay this minimal obligation. If the area is big, but crops are not sold, this is a big burden on the landowner. A lot of time passed since 2021, but situation is not changed. And for them, well, they believe that land tax and minimal tax obligation the same thing. It is not, because this minimal tax obligation includes only military levy and other things. And people are confused. It's very difficult to understand this legislation. I want to emphasize that minimal tax obligation is calculated differently. Whether monetary assessment of the land plot was conducted or not. If monetary assessment was not conducted, one takes into account the area of this land parcel. If monetary assessment was conducted, in that case, one should take a percentage, a certain percentage of this monetary assessment. And again, it differentiates whether it's agricultural land, forestry, or land of general use. And within 1 year period, local councils publish this information before 15th of July for landowners and renters to know how to calculate it. But many land parcels are located in area of hostilities, and this minimal tax obligation is paid nevertheless. Number of other problems arise regarding payment of land tax. The issue is that the basis for this tax is your registration of your land parcel in the land cadastre, but not all land parcels are in this register, especially those who are in the area of hostilities. So what happens? Either tax is not paid at all, or on the contrary, there is additional payment both by landowner and land renter. So both the owner and the renter are paying this tax. And there are many tax disputes considered in the administrative court regarding that. I found the case law of cassation administrative court where an applicant is asking to cancel the decision because tax amount for the rent is calculated improperly, saying, I have 38 land parcels, but one is not in my ownership anymore, and tax should not be paid. But cassation administrative court rules that the ground is parcels that are registered in the state register and decisions of local self-government. And first of all, what is in the state land cadastre? Only in very rare cases they take information from them other sources. In this case, it was in the register. Changes in the register were not made. And therefore, that person was supposed to pay rent pay and to pay for that again. What is also important, it is important in the land cadastre, there is the use, the intended purpose of the land parcel is mentioned in the land cadastre in order to calculate the tax properly. Other big problem arises not only in paying for land parcels that are in ownership, but paying tax for lands that are leased. Why that happens? In order to pay the rent, the normative monetary assessment of the land parcel should be made. If it is not made, then a certain formula is applied to calculate it. If monetary assessment is made, then changes should be made in the land rent agreement. Then Grand Chamber made a decision that happened on the 5th of June 2024. Grand Chamber, after analyzing norms of law, ruled that if Article 271 of tax code is used regarding the new size of monetary assessment of land parcel, that happened automatically, and parties of this agreement must not conclude a new additional agreement. In this case, local councils appealed to the partnership, asking to make a new agreement, mentioning that monetary assessment change and the amount of rent fee should be changed. But it did not receive the answer and then went to court, asking the court to recognize that this agreement has happened. But Grand Chamber said that as additional agreement should not be concluded. New assessment and change of the amount is sufficient, and tax should be levied based on the new monetary system. Another important thing, since local council went to court using the instrument which does not have the proper format, they were refused.
В якому зазначати про стягнення уже цієї орендної плати з іншої сторони.
Another claim should be filed for collecting the rent payment from another party. During martial law, many problems appear on paying rent, on lease payments, on payment of the landowners for the land, and the state regulation of payment for the land in Ukraine is not easy, and it depends on the type of land, the purpose of use of land, the normative monetary valuation, whether it was conducted or not, and final amount of tax is affected by the coefficients and other indicators. It is the subject of ongoing monitoring, examining, and further discussion. This is it from me. Thank you very much for your attention. Thank you, Olena Anatolievna, for this comprehensive research. It is visible that justified analysis, deep analysis was touching on many problem issues of land tax. You are familiar with up-to-date case law related to recent changes when on to rethinking, reconsidering benefits that were provided. The legislator is trying to adjust the benefit amounts and hostilities were replaced by active hostilities as a term in legislation, and they try to have attractive nature these terms, failing to provide stability and legal certainty and taxation, and also legitimate expectations of the taxpayers. In the same way, there are issues of normative monetary valuation and percentage identified in the decisions of local councils. You rightly emphasized the position of the Great Chamber, although it doesn't examine this issue substantively, but there are conclusions in the resolution and they should be applied. We have questions on actual and registered land user, because in some legal relations, the actual land user is paying the taxes when the rights are transferred for real estate on the land plots, and other legal relations are related to farming and agriculture. It is registered land user who is paying the taxes. The issues are in the work. We're working on those issues. They are very important, very urgent. Thank you for raising this topic. Thank you for your interest and for exhaustive answers to the questions based on available legal positions of the Supreme Court. Not taking too much time because this topic can be discussed for a long time. I pass the floor to my dear colleague, Mr. Igor, for introducing our next speaker. Ms. Irina, thank you. Let's move along. Our schedule is move according to the agenda. I am pleased to present our next speaker. This is Larissa Viktorovna Trofimova, the charge of the Cherkasy District Administrative Court. The candidate of legal science is the associate professor, the senior research fellow. Larissa combines court activity with education and research and civil work. She actually participates in judge self-governance. She actually promotes modern research and implementation into the practice. Her research in financial control and stability of public finance is widely used in professional community. Her topic of her presentation is public finance as the guarantee of recovery of development of Ukraine. Larissa Victorina, the floor is yours. Larissa Vitalyevna, the floor is yours.
Щиро дякую. Сподіваюся, що мене чути.
Вас чути.
Thank you. Hopefully you can hear me.
Слайди передані організаторам.
I pass the slides to the organizers if you share the presentation.
Хвилинки на слайд достатньо, а я буду в
Please
контексті
wait for my
промови
reminders. In the context of my speech, I will try to cover what is not possible to cover within time allocated to this presentation. Thank you very much for the invitation to participate in this distinguished event. It's very useful.
бути учасником цієї конференції.
It's great to be a participant of this conference. The topic is not selected by chance because it is formed based on the result of review of greater number of cases on taxpayers who have the status of IDPs and they move from the occupied territories, temporarily occupied territories. They left Ukraine and they believe that they can build back better. They can recover Ukraine. I'd like to say that tradition administrative justice in Ukraine, the days of administrative justice in Ukraine is the bridge, a function of platform to exchange between research and enforcement, to have new ideas and fundamental conclusions. As Larissa Fedorina mentioned yesterday, there's a consistent link between the past, the present, and the future. Unprecedented process of recovery of economy and critical infrastructure during martial law and migration, ensuring stability of Ukraine and proper effective security of each one of us. It is based on public finance and great assistance of international partners. The key role in all these processes is played by the judiciary. Justice is the mechanism and magnet for attracting investments. Next slide. I'd like us to remember that during peacetime we had 17 UN Sustainable Development Goals by 2030. Ukraine adopted its own laws and regulations on UN SDGs, as Mykola Petrovich mentioned, the public finance movement. The money is generated and allocated and reallocated and used. And the market economy is developing. Yesterday, I looked at in the first 2 quarters of 2025. In Ukraine, there was growth recorded of sole traders. More sole traders opened activity than those who stopped activity. It is the positive marker that we can take into account, positive indicator. There was growth in education, retail trade. The leaders include also delivery and postal services, real estate, and wholesale trade. The activities observed in repair of computers, equipment, and telecommunications, waste collection and recycling. We need to understand that in this movement in public finance, the great significance belongs to the crisis of benefit system, justified benefits, real financial capabilities, non-discrimination approach. Vasily's presentation covers automation of processes in the system of taxation. It is worth mentioning that many Ukrainians left abroad. They receive pensions in other countries, and we need to understand that even automated processes which are envisaged when they receive benefits and pensions
коригувати алгоритм. І
algorithm
тоді
cannot take into account
виникає
everything, and then pension
право
funds in these
використовує макетну
cases
обробку, бере
uses the
зміни
mock-up
фонду.
process and
Є
they take the permits of the pension fund.
є
This is
певне
an
регламент.
intervention. There are some
Інколи
rules and
внески
procedures.
бувають за змінами. І
Sometimes
відбуваються
changes
такі
are happening too fast,
втручання, які
and there are
не завжди
interventions which
на користь особі,
are not always in
яка
favor of the
має бути
individual
захищеною
who has to be
забезпеченням гарантій.
protected,
Тому
and
маємо це
guarantees have to be
враховувати
provided. We
під
have to
час
take this into account
застосування
when we
конвенції вимог сучасності
do
щодо
enforcement in the
змін
context of modernity, taking
міграції
into
та
account
тривалості.
demographic
І
changes and
ми
migration
тепер зрозуміле
that took
законодавство
place. If we talk
маємо
about clear
сказати,
legislation,
що
we need to say
суддям
that
довіряють платники податків, вони
taxpayers
звертаються до
trust
суду, ті
in the
тільки
courts, they
справи
apply to the court.
невпинно
Number of
змінюються,
cases is
і
on the
все
rise,
це позначається
and
на
this
публічну фінансову політику, яку
impacts the public finance
формує
policy,
не тільки держава, а й
which is
органи
developed
місцевого
not only
самоврядування,
by
а
the
також
state but also by local governments and
самоврядування,
public
сплачуючи податки, які потім
enterprises. They pay
наповнюють
taxes,
той
and
ресурс,
then
який ми можемо використати
these
для
are revenues
проведення
which we can
відновлення.
use for recovery.
Далі варто згадати
It's
те,
worth
що
mentioning
не
that
все так гладко.
not everything is so smooth.
Відповідно, є податкові правопорушення,
There are
якщо
tax
можна наступний
infringements.
слайд,
Next
і
slide.
ми маємо дбати також
And we have to
щодо
take care
зловживань і
that
ухилень.
we avoid abuse and evasion.
Сьогодні пані Оксана
Today,
говорила
Oksana
про те,
mentioned
що от в сегменті
that
банківського законодавства
in banking
є
law,
відносини,
there are
які
legal relations
прохідні між
between
банківським обслуговуванням, між суб'єктом, який обслуговується в банківській установі, і
the
регулятором
clients,
НБУ, комерційні
between the
банки,
bank
інші
and the
банки.
regulates the
Там є
NBU,
правила
between commercial banks and the clients.
внесення готівкових
And there are rules of depositing
є
cash.
розуміння каси або відсутність каси у тих чи інших суб'єктів господарювання, але є каса в банківській
Some
установі.
entities work with cash, some are cashless, and also there is cash in the banking institution. And when there is hidden
платежу з метою уникнення від здійснення
purpose of
фінансового
payment to bypass financial monitoring, to bypass AML rules, the bank may not see it, but controlling agency may see this, and also the court when they examine the evidence on the case. It's worth remembering the standards of BEPS and mechanism of tax planning and dispute resolution according to EU model. We should safeguard justice and effectiveness for allocation and reallocation of resources and use of resources. If we talk about use of resources, legislative changes and the temporary military tax. You remember it was 1.5%, now it was increased to 5%. There are some exemptions for military personnel. Well, also there's staff members of the armed forces, and there are also some specificities of enforcement. In the context of modernization of tax relations, it's worth mentioning the law on tax mediation, which is drafted and it's worth attention. So if we talk about this further, the role of the court is important. Let's remember the conclusions of the High Commission on the quality of court judgments, and when the taxpayer cannot bring documents from temporarily occupied areas, they apply with a request to controlling agency. They mention tax periods, reporting periods, and the controlling agency does not assist the taxpayer. They do not provide proper support on the client-oriented service. The court has the great role to resolve the dispute, taking into account the criteria envisaged by Part 2 of Article 2 of Administrative Code. We have to check actions, individual acts of controlling agency, which will help to ensure proper legal relations and recovery of Ukraine in the context of proper public finance. I would like to discuss the case of the Great Chamber 876. It was reviewed in June 2026. It is the judgment on tax case that was reviewed by ECHR. 5 cases were combined. Bukovsky et al. Versus Ukraine. Tax office accrued big amounts, more than 60 million. Supreme Court acknowledged that rejection of the claim is legal. ECHR established that there is a lengthy court review, Part 1, Article 6 and Article 13 of ECHR. The Great Chamber mentioned it is not impossible to recover this right about a reasonable term. The judgments that were made on the case, they were not put in doubt, and the European Court did not recognize that additional accrual of tax is illegal or incorrect. So, in the context of regional term of case review, we should take into account the burden of the court and all the court instances. We need to remember that prevention of conflicts, high-quality interpretation, and ensuring social cohesion, this is achieved by legal certainty at the standards of effective justice. Next slide, please.
As regards the revenue of public funds, tax discipline is important. In the context of tax discipline, I want to mention that we have guiding UN principle as regards business and human rights. There are 3 pillars. European Union is using these standards in its legislation, and we also use it in the court doctrine. That is especially important in conditions of war. Sometimes this is the issue of forced leaving the territory, there are frauds, or there are cases when the taxpayer is using different manipulations, paying taxes the wrong way. We should take into account all nuances that can be used by taxpayers. As regards tax discipline and responsibility of taxpayer, in the meaning of understanding tax obligations of the state, EU directives should be mentioned regarding sustainable development and reporting based on sustainable development. Using soft law acts, we can enhance motivation of court decisions. A fair taxpayer must keep the requirements regarding the taxpaying address. There was a case when a woman with 3 children left for USA. And then documents came to her address in Ukraine. Apartment was closed, she didn't pay tax, then fees were calculated, penalties. There are many circumstances that court must take into account, but it must take into account the fair approach of tax authority, and when we conduct judicial control, we must take all the circumstances into account. Next slide, I want to draw your attention to what was mentioned many times today, regime on the occupied territories. There is a law assessed by the court. There are different jurisdictions. There are certain issues in economic law and in criminal, but still will remain The next slide, I want to draw attention to different issues that need confirmation or no confirmation. The law that we mentioned regarding behavior on areas of hostilities. It is mentioned that economic activity is banned. Economic activity could be allowed only if tax address is changed to the address in the territory controlled by Ukraine. One should draw attention to the fact that whether the taxpayer filed tax reporting in the proper way. Supreme Court, in one of the cases, cancelled registration because of not submission of tax declaration, and the taxpayer had negative amount of VAT. Because of the cancellation of this status, all this money was calculated as the overpaid, but he didn't file the application. While continuing operation, issuing tax invoices, so the court took that into account, and the taxpayer didn't cancel the status. When defining all these conditions during law enforcement, one should be very attentive and careful and use legislation with consideration of all circumstances. Today, Mykola Petrovich spoke about deadlines. One should mention that pertains to such a group of participant status of internally displaced person, responsibility for mistakes in administration, what is written in Article 42 in tax code, if controlling body sent to the known address specified by the taxpayer, Article 45 of the code levies additional duty on them to check the data in the state register regarding possible change of domicile address, a place of address registration. I had a case regarding single tax payment by a defense lawyer. She sent all the tax documents at the previous address where she lived before beginning of the war. But that person continues functioning, not changing the address officially. Such things happen when all consequences are not taken into account. We have renewed the deadlines for this defense lawyer and helps him to manage the case. But all that requires additional time and resources. And we must take into account the fact that now we have the possibility to change legislation regarding electronic reporting, electronic change in the information, this digital instrument that will help taxpayers who have status of resident or not having the state of residence in order to improve revenues to the budget of Ukraine. Next slide. Much was told about territory already. The law on amendment to ensuring rights and freedoms of persons living on temporary occupied territory changes were made to the definition of temporary occupied territory based on Council of National Defense and Security definition. Different decrees of Cabinet of Ministers also should be taken into account. Supreme Court wrote quite well on that. Later, I shall show the cases from Supreme Court that take into account all these changed norms. If we look at all these deadlines attentively, and this is corresponded with the statement that Council of Judges is reviewing the request of providing additional number of court assessment to improve the quality of court decision, to check up the norms, how the new bases are being formed. All this difficult during the regime of martial law in order that they do not change the work, but important is that all these changes will facilitate exercise of justice. Then we have more subjects like what we had ago. And there was a judgment about a taxpayer who was registered in Kherson Oblast, had trade patent, international operations. He was the founder, conducted scientific research, and he had a production facility in Kherson. Then this territory was temporarily occupied, and all the land and all the premises were lost immediately. But this taxpayer did not surrender. He re-registered in Cherkasy region and addressed tax authorities, asking them the proper article of the tax legislation. Then tax authority made a decision, a protocol of commission and decision of controlling body. And the taxpayer who was asking about tax period, about change of periods, all that was left outside scope of attention. Then the court cancelled all this previous decision and obliged tax authorities to review this case again with the explanation about specification, how to restore banking documents, and how to use primary documents in his activity. Although during all this period from 2022 until 2025, the taxpayer was filing his tax declaration. AI was mentioned today. So what that taxpayer received, the printing of all the invoices that he was sending to Germany, to Sweden, even to Russia. What resources did use? What operational system was used? All is absent. As a taxpayer is trying to restore his activity in the territory of Ukraine, is taking all measures. We must take a careful and reasonable approach in order that we apply legislation qualitatively, exercise effective judicial control, and separate a presumption of the lawful decision of taxpayer from discretional action of tax authorities. Next slide. Examples, cases. I will not speak much on them, just draw your attention. Supreme Court have started all these issues of occupied territories. These cases differ in one thing. Important is who was transferring money. Payment in cash, transfer of goods. They are different operations that require different mechanism of tax control. Sometimes it's Treasury who's responsible, then it's something else. According to bank instruction, if when money is transferred and mistake is made, then the agents must settle it between themselves. One should pay attention into all these details, and Supreme Court did pay attention to it. And now they ask to create a reserve copy of computerized information. So we come to the new digital documents. Next case pertaining to what kind of activity was conducted. If a person was leasing premises in that territory since 2019, then 2022 war started. The rent continued and all payments were coming. One should separate the essence of operations themselves. Supreme Court is paying special attention to all these issues. I would draw your attention to the fact when assessing proofs how important it is to take into account all these legal features. Legal person or personal. And you should pay attention to particular formats that register property if the land that person owns remained in the occupied territory. Yesterday, there was discussion of the historical aspect. How measures were taken in order to introduce new instruments in financial policy. The old time, the Hetman time was recollected. In the context of land ownership, I must say that one of the hetmans had an advisor who was Pole scholar, Vyacheslav Lipinski. He wrote a book about wheat growers, prescribing regulation of land ownership and rent. If we take into account previous experience, what was offered, what was adopted, what was rejected, maybe our procedures will become better. Last one, in conclusion, I want to say important is how media is providing information. I am pleased to say that Press Service Supreme Court responded quickly to incorrect coverage of the case by media regarding extraordinary review of decisions of lower courts. Before, Supreme Court didn't pertain to it. So the way how information is presented, how we describe the action judiciary is very important. The need to reduce workload on the courts, introduction of court assistants. What should be done to sustain judicial system in its efforts to work effectively and resolve cases properly? Юридична газета newspaper pays much attention to it. Therefore, next slide. One should pay attention to the fact how judges are responsible for reasoning of their court decisions. A claim or filed by a citizen of Ukraine against State of Ukraine, against Supreme Court, to cover moral damage. Important is that judicial system wants to achieve beneficial and flourishing Ukraine, that people's rights are protected. And instead of conclusion, I want to thank you for your attention, because financial support of Ukraine is important. Compensation for ruined property, return of assets and sanctions, register of damages, ensuring stability of financial system, grants and loans. That is important for recovery of Ukraine.
Лариса Віталіївна, дякую за таку цікаву,
Thank you very
всеохоплюючу
much
доповідь.
for such
Безумовно, тема є
comprehensive,
надзвичайно
very
актуальна
interesting
у
report. The
умовах
topic is
якраз
very
воєнного
significant.
стану,
In
післявоєнного
conditions of
періоду,
martial law,
ефективне управління публічними
post-war
фінансами є ключовою передумовою забезпечення
reconstruction
макроекономічної стабільності,
is
фінансування
important for
відновлення
ensuring
соціального
macroeconomic
захисту населення та
stability,
сталого розвитку України. Ви дійсно дуже вдало
renewal of social
вперед
infrastructure. You
таких
quite
важливих питань,
well
і
covered
дуже цікаво
entire
були
range
якраз
of all these
акценти,
issues.
які ви розставили на судовій
Focus that you
практиці.
made on
Безумовно,
judicial cases, very
виклики є
interesting.
значущими і такими великими,
Challenges
але
are
через те, як ви розкривали
big,
цю тему,
but how
це
you
було
disclosed
надзвичайно
this
цікаво,
topic,
бо
it
ми
was of
навіть
great
не
interest for
промоглися
everyone.
зауваження, які зробити щодо кількості слайдів, тому навіть
We even didn't have the possibility to
жодної думки про
make
це,
a
але
comment
дійсно
regarding
всі
huge number of
були
slides.
зацікавлені, тому
It
надзвичайно
was so
цікаво.
interesting.
Я вам скажу, що ваша доповідь буде мати дійсно таку практичну цінність, оскільки якраз вона посприяє розумінню
The presentation will promote the understanding of public finance, taking into account case law and the developments of legal relations, all the details you mentioned, and previous speakers mentioned this as well. It was very interesting. Also, we're all trying the public finance to make sure that public finance is used transparently and efficiently and effectively for recovery of our state. Thank you very much once again for this informative and interesting presentation. And as promised by Ms. Irina, my co-moderator, we go back to our previous speaker, Vasil Vasilovich Ilkov. We promised to give him the chance to talk to the audience. So, Vasil, please, the floor is yours. We still have time for Q&A session. It's not just Q&A dedicated to your topic specifically. It's also Q&A for other speakers as well. If the audience is ready to participate in the discussion, to discuss issues presented, please get involved. Irina, do you support me in this idea?
Безумовно, так, ми обіцяли Василю Васильовичу
No
і всій
doubt
нашій
about that. We
аудиторії.
promised Vasil in our audience to have Q&A session. Please, Vasil, the floor is yours.
Дякую вам, шановний
Thank you, dear moderator,
Ярославовичу.
dear Igor Yaroslavovich, dear Irina Leontievna.
В мене є, бачу, в
I
чаті одне
have
запитання.
a question in the chat,
Є піднята рука.
and there is a hand raised from the participants. Larissa Vitalyevna, please.
Питання загальне, а у вас, можливо, по тематиці саме доповіді.
Maybe it's a question on the topic of the presentation. In your presentation, you discussed the registration of tax receipts, and you mentioned that automated software does the accrual. Yes, the first receipt, which establishes the deviation, it is done by the machine through the algorithm. It determines the indicators of DEP. DEP is the deviation. How does it come up with those indicators? It takes those indicators from the reporting, which is published in the database. In the context of comparison of the indicators to the previous and next volumes of sales. So all can be verified, but we need to understand that if we have 15 tax notifications and decisions in one court claim, or hundreds of registrations of tax receipts, and we don't have the coefficient of burden on this case in the database. Another coefficient except the coefficient of collection of tax debts. There is draft law to remove this category at all. This has to be reflected in the burden and coefficient. When there is more time, we can review the reporting provided, the indicators, requests from the taxpayer, and oblige another party to provide information, and then we can understand this deviation indicator. If it appears, we can identify if the taxpayer is risky or not, based on the Ministry of Finance methodology that was published. This is my proposal on efficiency and capability to apply AI. Thank you. Thank you, dear Larissa Vitalyevna, for your discussion. Indeed, I was trying to present one of the aspects that we encounter in the work with tax office. As you and Larissa mentioned, and other presenters mentioned, we're called to protect the interests which are prevailing in this case. There is interest of the individual behind this. It is implementation of rights. The problem is about the indicators, the database that was created and implemented. As the first instance court, you understand that we cannot understand the logic of tax office in certain situations. In some circumstances, the tax office cannot understand this as well, because they have only the code developer can understand this. And also developers who are implementing this system, they can understand why the system works in a certain way. So I support the logic. We need to understand how the algorithm works and what are the consequences, what was the impact, why it happened so. And they say that the information is not available. We don't know. There are other circumstances that we need to clarify and find out and identify. I agree with you. Maybe it should be regulated properly in the regulation on AI. The Supreme Court has the rules of use of AI. The Supreme Court was the first to apply the algorithms of AI in the judiciary. There is one more additional question. We can look for legal positions and use this Supreme Observer engine of AI. So I support this important aspect for further development, an aspect of protection of rights and freedoms and interests of the individual. Thank you for your question. And we have one more question and the hand raised. Mr. Volodymyr, the floor is yours. Good afternoon, everyone, dear participants, dear guests of the conference. Vasil Vasilievich, good afternoon. To answer a question in the context whether we use the algorithms of AI in our day-to-day activity. Maybe the first point in this question is that acts a boisterous development of digital world. We cannot stay aside of this process, and in any case, it seems to me that it's not the issue whether to use AI in day-to-day activity or not, and the same as in the judiciary. On the other hand, we have some concerns about AI use. We paid attention to personal data protection and information security with limited access. And as a proposal or the call for leaders of the judiciary we as first instance judges, it will be useful for us, and it would be easier for us to use AI algorithms, because we understand that in any case we're all users of ChatGPT, Gemini, and others. If the judiciary establishes the rules of use first, and then second, to create the platforms for use of AI algorithms, to share responsibility with us as first instance judges as regards the rules of use. And the last point, doing count in our day-to-day activity, the use of AI algorithms, I can see that many times we encountered in explanations of parties, we see that documents are drafted with the assistance of AI algorithms. I cannot always establish this directly. Some bold judgments of the Supreme Court are doing this. Thank you for these judgments. But in any case, we respond, we make response. Like there are some issues of abuse of rights and so on. Well, the parties are using AI actively, unlike judges. So my proposal would be very feasible. Thank you, Vasil Vasilovich.
Дякую, Володимиру Володимировичу.
Thank you, Volodymyr Volodymyrovich.
Насправді,
You know, actually,
скажімо, навіть вчора я вийшов з
even
засідання,
yesterday I left the court session. One of the documents that was submitted was structurally, it looked like AI-generated documents. That is, short phrases, highlighting some sub-items, some general, not very logical, in terms of dialectics, conclusion, short machine-generated text, and we are on the way of massive use of AI by the parties to the cases for drafting documents. Also, I'm grateful to all the international partners who are involved in this international conference. Your experience is very important for us. We also use this international experience. You know, in the West, the information that for every judge there is a profile that is generated in 2018, so-called French experience that took place, you know, about this on the basis of this experience. The block was generated dedicated to justice in CPECH Convention on the use of technology and AI technology. And the issue has arisen why courts are using some practice in the same category of disputes, in the same legislation, and there are different judgments. And they wanted to automate the system fully, to make sure that judgments are made by AI. They decided to implement this project. They monitored all judgments of the courts, of the judges, and all in this category of cases. They established the reasons, the circumstances that were examined, what was the basis of judgments, what was the regulatory framework, why there was rejection. 2018, it was implemented completely. The problem was that AI system was not able to build a dialectic linkage between the circumstances and consequences. The key point is AI is not able to make the court's judgments. It is an important component. It's the concept that AI is not capable of replacing a live judge. The judge
який використовувався податковою при
is to
винесенні
understand the
того чи іншого
algorithm
рішення.
that was used by the tax office in making the decision. There is full automation now.
Продовження тої тези якраз
It is the continuation of the point that you mentioned earlier, dear colleagues.
давно вже, наприклад, не може
For a
прийти
long
навіть
time,
інспектор і в
even
зворотній
inspects
податкової картки платника податків пояснити, яким чином формувався податковий борг.
explain in the card of the taxpayer how the debt was formed, how the penalty was formed. It is automated. The person cannot explain this.
Є реалізація.
So there is
Якщо
implementation.
дозволять модератори, є ще
If I'm allowed by the
питання,
moderator, there is also the issue. I can see the question in the chat. It is also the question
Не
from
перебирайте
Volodymyr.
нашу роботу, будь ласка, пане Василю.
So do not take over our work, Vasil. Yaroslavovich, I also have a question later on at the end.
З дозволу
Пані Ірино, то прошу
Miss Irina,
щодо продовження дискусії.
to continue our discussion.
Дякую, пане Ігоре.
Thank you,
Володимировичу, ми
Igor.
вас
Igor
почули, і
Volodymyrovich, we have heard you
обов'язково надамо вам
and
слово для
we'll
запитання.
give you the floor for
Але
question.
у
But
організації таких дискусій важлива
in organization of these discussions, it's important to have consistency. First come, first served. So first hand raised, first question asked. In the chart, I see the answer to the question. I can see on the one hand raised by Igor Volodymyrovich. So I'm pleased to pass the floor to Igor for the question. Consistency is very important. That's true. Vasil Vasilovich always has interesting presentations. I'm always glad to listen to him, and many times we participated in study tours and many activities and events in Ukraine and overseas. And I'd like to ask a philosophical question. AI topic for me is new and interesting, just like for everyone, I believe. And everyone is asking a question for themselves. It's a philosophical question for discussion. Where is the limit, in your view, Vasil? Where does this limit lie between acceptable assistance of AI and unacceptable impact on internal conviction of the judge? What do you think?
Дякую вам, шановний.
Thank you, dear Igor Volodymyrovich, for your question.
Ви знаєте, це
You know,
ключове зараз.
it is the key issue at the moment.
Програми розвитку
The
та
concept of
запровадження
program of
штучного
development and
інтелекту,
implementation of AI,
так само системи
development
електронного
of the
суду,
e-court
самої
system
судової системи.
and the justice system overall.
Для
No
того,
doubt,
щоби
in order
можна
to
було,
be able to
використати
use
повний об'єм, повний,
full
напевно,
scope,
той позитивний вплив штучного
full
інтелекту,
positive impact of
повинні
AI,
бути певні обмеження.
we need to have some restrictions, we need to have some limitations.
Сформований безпосередньо прийнятий єдиний кодифікований акт в рамках Європейського Союзу вказує
Yeah,
про
Lex,
те,
the
що
Unified
найвищий
Codified
ризик
Acts
це
in the
правоохоронна
EU is
діяльність,
mentioning that the
саме
greatest risk is law enforcement
сфера.
activity and judiciary.
Тобто дуже потрібно бути обережним.
We need to
при
be very
реалізації
cautious when we
штучного
implement
інтелекту.
AI in judiciary.
Окремо, звичайно, дякую також за той акцент, який ви сказали.
Thank you for your emphasis. We have Article 16 of the Code of Judiciary Ethics. That is the only regulation containing the provision on application of AI at the moment. We have a limit. Yes, the judges are allowed to use AI, but we need to remember that the taboo is examining evidence and making judgments. Many representatives of lawyers upload in the profile of the judge all the judgments made by the judge, and AI in theory can provide answer what judgment is projected by the court. 85% is ready. So I fully support your idea that the judgment of the judge's discretion is the key for decision making, and no AI algorithm is able to replace.
Вибачте,
Sorry,
вибачте, зв'язок.
we have some connection issues.
Зв'язок.
Ми вас чуємо.
I can hear you.
Ага, вибачте, це нас,
Ну,
напевно...
ключове ми почули. Не може замінити.
So
Не
it
може
is
замінити.
impossible to
Не може
replace
замінити людину, це
a
нас,
judge
напевно, просто
by
проблеми
AI.
в зв'язку з атаками. Вибачте.
We may have some
Не може
problems due
замінити.
to
І знову ж таки, зараз
attacks.
ведуться
So
певні
substitution
процеси
of humans
щодо
is not possible.
запровадження постанови
Now there are some
Кабінету
processes to
Міністрів,
implement the
що
resolution of the
буде
cabinets and
проводитися
ministers to
автоматизація
introduce
розгляду
automation
судових
of
справ певних, скажімо, в
court
найпростіших
review in the
справ,
simplest
кодексу
cases
адміністративних
of
правопорушень.
the administrative infringements
Але знову ж
codes.
таки,
But once again,
наслідки,
the issue is the
питання
consequences, the
подальшого
issue is
оскарження,
further
дуже
appeal.
багато питань по
There are many
реалізації.
issues
Крім того, ви
on
знаєте,
implementation. Also, you know,
розширення
the expansion
самого
of
концепції програми
the
розвитку
concept of
електронного суду.
program of development of
В окремий
e-court.
блок пропонують
There is a separate
включити
block when it is suggested to include automation, which will control the adherence
самого
to
безпосередньо, скажімо, етапу дослідження
the
доказів.
stage of
Без
examining the
якоїсь,
evidence.
без якогось доказу неможливо буде
Without evidence, it
скласти
will be
рішення.
impossible to
Чи,
draft a
скажімо,
judgment or
використання актуальної практики
the use of
Верховного суду.
up-to-date
В рішенні
case
не
law of
буде
the Supreme
процитована
Court.
відповідна
If the
практика
judgment doesn't
Верховного
quote
суду,
the
то
case law of the Supreme Court,
суддя автоматично просто
then
не
the
зможе
judge automatically will not be able
підписати це
to
рішення.
sign the judgment.
Тобто, ну, розробки вже готові
The developments are
реалізувати
ready
ці сфери.
to be implemented in this
Тому дуже
area.
дякую за
So thank you very much for your
запитання, дякую
question
за увагу.
and thank you for your attention.
То я відрефлексую. Саме вам хотілося
I'm
питання
just
задати, тому що
reflecting.
зараз, можливо,
I
хтось
wanted to ask this question just to you.
питання, а ви відповіли.
Some people may
Відчувається,
say
що
that
дуже
I have
глибоко
prepared this
розібралися
question
і
in
цікавитеся
advance,
цією темою.
but it is not.
І також
I
багато ще питань
see
з цього приводу
how
будуть
well you
виникати,
started the
наприклад,
topic,
коли
and
суддя
more
перед тим, як
questions will
прийняти
arise,
рішення
of course.
і дійсно
When a judge,
використовує
before
щит,
making a decision,
повинен
is
він
using
повідомляти
AI,
сторони,
whether a
що при
judge should
написанні
inform the
рішення
parties that when
використовувався
compiling
штучний
a
інтелект.
judgment, a judge used
Дискусійне.
AI.
Я вважаю,
It's
що
also a
ні, тому що це
debatable
буде
issue. I
підстава
think
для
that not,
апеляційної
because
скарги.
otherwise
Ну, а
it will be
взагалі-то
the
дуже
basis
багато
for
і
the
процесуальних
forthcoming
моментів, тому що
appeal.
ми
But many
відчуваємо
other
всі,
procedural
думаю,
questions
розуміють,
will
адвокати,
arise.
скажімо, що практично зараз
I
всі використовують
understand
штучний
that
інтелект.
now
ChatGPT
everybody is
використовується
using
взагалі
AI.
постійно.
ChatGPT is used
Тому,
permanently.
відповідно, і
Therefore,
питань і підстав у сторін буде для того, щоб
the
знову
parties
ж таки
will have
реагувати на
more
це. У
grounds
нас
to
і так скарги
respond
пишуть
to it.
без приводу і з приводу.
Even without
А
that,
то ще
many
і це буде
complaints are
зачіпка
coming. But that
сторін
will
і
be
для
another
сторін.
reason for the
Тому
parties, and not
дякую,
only.
Василь Васильович.
Thank you, Vasil.
Дякуємо і вам, Ігоре Володимировичу, за жваву
Thank
участь
you,
у
Mr.
дискусії.
Dashutin, for your
Питання
active part in
надактуальне,
discussion.
дійсно,
The
дуже
question
своєчасно
is
підняте Василем Васильовичем і
extremely important
викликало
and very
жваве
up-to-date.
обговорення серед
Therefore,
учасників.
discussion
І
was so
пан
active.
Володимир перевів його на площину правосуддя.
Volodymyr switched to the area of justice, although initially we discussed it in the sphere of VAT administration. But I would like to take part in this discussion as well. We all, judges, realize very well that use of AI is an impact on our unbiasedness and is shaping inclination to certain type of consideration. Therefore, we should refrain from prompts made by AI, but how to recognize the document prepared by the parties with use of AI? Normally, AI is inventing caseload which is not relevant and circles consideration. When the statement is made based on arguments that starts from the statement itself. So it is a vicious circle of evidence
алгоритмів
In
штучного
that
інтелекту,
case,
які по
you
суті
will
є
merely
масштабовано
recognize
Д9.
that
Це словоблудие,
it is
грубо кажучи. І
artificially
якщо немає
generated
більше
document with
бажаючих
the help
взяти
of
участь
AI.
в
If
обговореннях,
nobody
тобто ми
else
на
is
себе
wishing to
дуже
take
приємному
part
місці, ми
in
всі люди, ми всі
discussion, I will take a
втомлюємося,
very
ми
pleasant
маємо
mission. We
якісь
are
певні
all human
потреби,
beings.
і
We're
кави, і
getting
поїсти, можливо,
tired. We have
то
our all
оголошую
needs. We all
про
want coffee.
перерву до
Therefore, I announce
14:00.
the break
Ждемо вас
until
з
2
Ігорем
p.m.
Ярославовичем
Igor
у
Yaroslavich
від'єднанні
and
всіх
myself
можливих
look forward to see you
смачної
at 2 p.m. again. Have a nice
Гарної перерви.
coffee. Have a nice break.
Доброго дня, шановні наші учасники, що приєдналися.
Good
Вітаю
afternoon,
усіх
dear
тих,
participants
хто
that
з нами
have
і
joined
в першій
us.
половині
And
нашого
I also
заходу.
welcome all those who took
Відкриваючи
part in this
заключну
conference in
сесію
the morning.
нашої міжнародної конференції,
I open the final
яка
session of
має
our
назву
conference,
«Фінансова відповідальність
Financial
та інші
Responsibility
питання податкового
in
правозастосування
wartime
у
and
новому
other
світі».
issues of tax law enforcement.
Насамперед сказати, що
First of
відчуваю
all,
легкий
I want to
смуток від
say
того, що все
that I
скоро,
feel
адже
a
небудь
little
має
bit bad.
закінчуватися.
I feel a
Ми
little bit
викладемо
sad
максимум зусиль
that all good
для того,
things
щоб
are
цей
ending,
фінальний акорд
and
звучав гідно
we
і
shall
не
take all
менш
effort that this
урочисто, ніж
final
попередні
accord
сесії нашого
will
заходу.
be as nice as the previous
Правом
sessions
почесним
of the
розпочати цю
conference.
фінальну сесію ми
The honorable right to start
наділили
this session
Олександра
got
Анатолійовича
Alexander
Лукашева. Це
Lukashev.
без перебільшення видатний юрист.
He is,
Він, як
without
показав успішне
exaggeration,
поєднання
a
академічної
distinguished
кар'єри
lawyer
та
who combines
законотворчої
academic career and
Олександр
legislative
Анатолійович доктор
activity.
юридичних
He is a
наук,
doctor of law,
професор кафедри
professor
фінансового права
of
Національної юридичної
Department of
академії
Financial
імені
Law
Ярослава Мудрого.
of Yaroslav
Він є
Mudry
членом
Academy,
науково-консультативної ради
member of
Конституційного та
Consultative
Верховного
Council
судів
at
України.
Constitutional
Разом з тим
Court
він
and
політик,
Supreme Court.
він народний
But he is
депутат
also a
Верховної Ради.
politician, a member of
Спочатку
parliament.
займав посаду першого заступника голови
First, he was
комітету з питань
first
освіти, науки та
deputy
інновацій,
chairman
а
of
нині
Committee
увійшов
of
до складу
Science
комітету
and
з питань
Education,
фінансів,
now
податку,
member of
ПАЕ та
Commission
митної
of
політики. Також
Finances,
він є
Tax
членом
and
дуже
Customs
важливої тимчасової
Policy,
комісії, що пов'язана
member
із
of Important
відношеннями під
Commission
час регресу та відновлення наших військових і багатьох парламентських
that
груп.
is discussing
Оскільки саме
violations
наукової
during the
консультації
regressive
важливим є
payments to military
багаторічний досвід
servicemen.
роботи у сфері
So
фінансового права
many
Олександра
years
Анатолійовича та
experience
підготовки
of
нових поколінь
Alexander
правників,
Lukashev
які дозволили йому
is
ефективно
very
долучитися до
important.
формування
He is
державної політики
also
у
take
сфері
part in
фінансів,
training of
оподаткування і освіти.
future
Його професійна
judges.
діяльність демонструє
His
важливість ефективної
professional
взаємодії
activity
академічної науки
shows
та
importance
законодавчого
of
процесу.
academic
У фокусі
research
уваги
and
концепція
practical work.
бенефіційного власника та
So
роль
title
державних
is
урядів
Concept
у
of
формуванні
Beneficial Owner of
комплексної
Income.
доктрини
The
з
Supreme
податкового
Court shapes a
питання.
complex
Прошу,
judicial
Олександр
doctrine.
Анатолійович.
Please, the floor is yours.
Дякую,
Thank
шановна
you,
Ірина Леонтівна,
dear
за таку
Irina
презентацію.
Leontievna, for
Подумав
this
про
introduction.
необхідність заявити про конфлікт
I
інтересів,
started
оскільки
thinking
ви не
a bit
можете, як і я до
about
вас,
possible
чи
declaration
ставитись
of
неупереджено,
conflict of
враховуючи
interest.
наше
Take
вже
into
понад
account that we
30-річне
have
перебування
very
цій
good
юридичній царині,
relations,
спочатку
30
як студенти,
years
а потім
joint
в
work
різних,
in the sphere of
в
law,
різних формах.
first as
Але
students
ж
and then at
юридична
different
спілка не лише
positions, that could be even a conflict of
Харківська
interest.
юридична школа нас
So
об'єднує, ми
Kharkiv
вихідці з
Law
неї, але ж
School
і
is
спільна
our
галузь
alma
юридичної
mater,
науки і сфера
but
практичної діяльності
we
також.
are also
Дуже приємно
working
бачити
in a
і
practical
друзів, і
judicial activity.
пана
I'm very
Ігоря,
pleased to
найщиріші
see
вітання.
friends.
Радий
Igor,
бачити і
my best
вітаю
wishes
всіх
to you as
учасників
well. Welcome to all
9-ї
participants
науково-практичної
of the 9th
конференції міжнародної, присвяченої
conference
адміністративної
devoted
юстиції.
of
Знаєте, я
administrative
вважаю, що
justice.
та
I believe
дискусія,
that
яка
the debate
мала місце на
that took
початку, на
place
зорі, або навіть
at the
передувала
beginning
формуванню
or even preceded
адміністративної
the
юстиції,
shaping
адміністративного
of
судочинства
administrative
в Україні.
justice
На
in
сьогодні
Ukraine,
вона здається цілком успішною, оскільки це
now
призвело
it
до
seems quite
формування
successful because
потужної
it brought
системи
us to development
адміністративного
of
судочинства
a powerful
в
system of
сучасній
administrative
Україні.
justice in modern
Переходячи
Ukraine.
до мого виступу, я б хотів би
Coming to my
звернути увагу
presentation,
на
I
концепцію
would like to
бенефіціарного
say
власника доходу,
how
а саме
important is the concept
той
of
спосіб,
beneficial owner of
який
income,
Верховний суд
how
формує
Supreme
судову
Court
доктрину.
is
Ця
shaping
концепція бенефіціар
court
чи
doctrine.
фактично
This
отримувача
concept
власника
of
доходу
beneficial
посідає одне
receiver
із центральних місць у
has
системі
one of the
норм
central
податкових
places
пільг
in
при
the
оподаткуванні
system of
доходів
limitation of tax
нерезидентів з
benefits
джерелами
when
їх походження з України.
taxation
Від
sources
встановлення
of
у
non-residents,
нерезидента відповідного статусу
when
залежить доступ платника податку до звільнення від
establishment of
оподаткування
status of
застосування пониженої
tax
ставки
resident
податку,
is
передбачених
important
міжнародним
because
договором
it
про
defines
звільнення
what
від
tax rate that
подвійного
person
оподаткування. І
is paying to
касаційний
avoid
адміністративний суд у
double
складі Верховного суду
taxation.
на сучасному етапі
Cassation Administrative
формує
Court
цілісну
is
правозастосовну
shaping
доктрину, яка дозволяє
integral
на нижчих інстанціях
legal
уніфіковано
doctrine that
підходити до
allows lower
встановлення цього
instance
статусу.
court to
І
have
в
unified
основу
approach
аналізу
to
буде
establishment
покладено
of
судові
status.
доктрини, які
So I will analyze
сформовані
court
постановою Верховного
doctrines
суду
that
у
were
складі колегії
shaped
суддів Касаційного
in
адміністративного
the
суду від
judgment of
24
Supreme
червня
Court from
2025 року.
24th of
Це
June
справа за номером
2025, case
120
number
104/139/24. І так, отже,
120-24.
стаття 103 Податкового
Article
кодексу
103 of
містить
Tax
дві
Code of
самостійні
Ukraine
підстави
contain
неможливості
two
застосування
independent
податкових
grounds
пільг.
where
Це
it's
тест
impossible to use
на
tax
особливу
benefits.
мову, це абзац 3
Text for main goal,
крапка 2, та
paragraph
тест
3,
на
and
бенефіціарного
test
фактичного отримувача
on
власника доходу. Це
beneficiary,
абзац перший
actual
пункту
receiver or
103.2
owner of
та
income.
пункт 103
Paragraph
3
1 of the
статті
same
103 відповідно
article,
податкового кодексу. Я
103
хотів би
of Tax Code.
зосереджити увагу
I want to
виключно
focus
на
attention
другій
only
підставі,
on
оскільки
the second
правозастосовна практика
ground,
свідчить
since
про
law
сплутування
enforcement
цих
practice
різних
shows
за змістом концепцій.
that these two concepts
Ось
are
концепція
often confused.
бенефіціарного власника
Concept
доходу
of beneficiary
у
owner of
пункту
receiver
103.3
in understanding of
статті 103
Article
Кодексу України не є
103
тотожною
of Tax
поняттю
Code is
кінцевого
not
бенефіціарного
similar
власника. Останній
to the
застосовується для
concept
встановлення
of
фізичної особи,
final
яка
beneficial
контролює
owner,
юридичну особу. Натомість бенефіціарний
a
власник
physical
доходу
person that
пов'язаний з
controls
правом
a legal
розпорядження
person.
конкретно
Beneficiary
отриманим доходом і має
owner
суд
of receiver is
податкове правове
connected with the
значення.
right to
Узагальнення
manage
позицій Касаційного адміністративного суду
the
у складі
received
Верховного суду дозволяє
benefit.
виокремити сукупність взаємопов'язаних критеріїв дотримання
Compilation of
надання
position
підстави
of
для
Supreme
висновку
Court
для
allows
висновку
to
про
separate
наявність у
set
нерезидента
of
статусу бенефіціарного
interconnected
власника доходу.
criteria that
І так,
allows to conclude that
по-перше,
non-resident
наявність у
has
нерезидента
a
формального
status
права
of
на резидентство.
beneficiary
Для його дотримання достатньо договірного
owner.
оформлення відносин між нерезидентом
First,
та резидентом. Це
availability
закріплюється право на
of the
отримання
formal
доходу
right
із джерелом
to receive
походження з
income,
України. По-друге,
with the source of
нерезидент
income from
не
Ukraine.
повинен бути
Second,
агентом номінальним
non-resident should
утримувачем або
not
номінальним
be an
власником. Його
agent,
право не
nominal
повинно
owner,
ґрунтуватися на договорі
and his rights should
взаємозахисників.
not be based on
Касаційний
intermediary
адміністративний
agreement.
суд послідовно
Cassation
підкреслює
Administrative Court
неприпустимість
emphasizes unacceptability of narrow interpretation of this criterion. What should be analyzed? Whether resident is an active company with diversified activity, or maybe it has intermediary activity. Whether the main objective of this non-resident is only intermediary function regarding the income that they receive. Then, important is the qualitative part.
отримання доходу. Але
So,
самостійно
the person must not only
визначати
have legal
і подальшу
rights, but
економічну долю.
to define
Поняття
independently
фактичного
its
отримувача
future
доходу не
economic
має тлумачитись у вузькому технічному
purpose.
сенсі.
It
Його
should not be
значення слід
interpreted
визначати,
narrowly.
виходячи
This
з мети та
concept should
завдань
be
міжнародних
defined
договорів про
based on
уникнення
the
подвійного
purpose of
оподаткування.
international agreements
По-четверте,
aimed at
кількісна
avoiding
сторона
double
критерію
taxation.
передбачає обов'язок контролюючого органу
Quantitative part of
довести
this criteria
співставність, в
provides
тому
for
числі
the
арифметичну операцію
duty of controlling
між
body
виплатою
to prove,
доходу
including
нерезидентом та подальшим
mathematically,
перерахуванням коштів з
operations
нерезидента. У
between
справі, що покладена
paying
в основу цих тестів,
income
Верховний суд звернув
to
увагу на необхідність
non-resident.
порівняння сум, виплачених
The
нерезиденту,
Supreme
із
Court paid
сумами,
attention that there
які
is a need to compare amounts paid to non-resident and amounts that paid to his beneficiary. If there is non-compliance, then transit movement is excluded. Fifth, availability of non-resident company of economic presence, substance in Ukraine, its incorporation. The substance is real staff, real physical office, active economic activity, bank accounts, local finance management, sufficient own capital and assets. Cassation Administrative Court many times drew attention to the fact that negative signs of substance indicate absence of own funds and assets, absence of staff, apart from chief manager, absence of premises, absence of real economic operation. Six, non-resident company independently take risks in connection with its activity. We need reflection of operation between resident and non-resident, or between the latter and the third person. This criterion should not be used formalistically, because in some branches, nature of agreements could be typical, and similar formulations are caused by the nature of relation. Important is minimal period of time between operations, but most important is the actual move of monetary funds, not their lengthy stay at the accounts. Temporal criteria, it's secondary. It cannot be individual basis for conclusion about absence of beneficiary owner. Important is issue of related person. Tax code of Ukraine does not contain this ground for cancellation of state as a beneficiary owner. Structuring of business model of group of companies is competence of shareholders, and the existence of network of cooperative network by itself doesn't show the absence of status of independent market participant. It's controlling body who must prove the motivation of activity of non-resident, that there is absence of real economic activity, possibility to act independently, take risk, and substance. Taxpayer must demonstrate substantiation of reasonability, business objective. The formula substance is more important than tax benefit. Substance over tax benefit comes into force. Practice of cassation administrative court shows that integral doctrine of beneficial income owner is being developed on the basis of number interconnected criteria from Article
жоден
103 of
критерій не
Tax
має
Code.
самостійного значення,
None of
а
the
ключову роль
criteria
відіграє
has
ознака транзиту
independent
коштів.
meaning.
За її
Important
відсутності
role is
підстави для
played
спростування
absence of
статусу
transit of
недосяжного
funds.
власника вважаються не
If
встановленими.
there is no
Подальша
evidence like
уніфікація
that,
підходів має забезпечити
cancellation of
баланс
status
між
of
фіскальним
beneficiary
інтересом
owner
держави
is
та
believed
правами платників
non-established.
податків в умовах
Further
воєнного
unification of
стану. Це
approach is
набуває
important to ensure
важливості та
balance
актуальності.
between fiscal
Колеги, щиро
interest of
дякую
state
за
and the
надану
interest of
можливість
taxpayer.
виступити.
Thank you for this
І
opportunity to speak.
тримаємо наш науково-практичний зв'язок і
We
сподіваюся на
shall keep
подальшу
in
співпрацю.
touch between
З повагою
us,
до вас, слава
researchers
Україні!
and academics. Glory to
Героям
Ukraine.
слава. Дуже дякуємо вам,
Glory to heroes.
пане Олександре,
Thank you
за
very
гарне
much,
представлення
Alexander,
цієї
for your
концепції на рівні
well-founded
практики
presentation
Верховного
of this
суду. Хотілося б
concept
почути
using
ще
the
про розвиток
case law of
законодавчих
Supreme Court.
ініціатив у цій
We would
сфері. Як
like
ми
to hear
знаємо,
more from you what
готується до імплементації
legislative
директива
initiatives are
ЄС
developed.
назад щодо
I know that
протидії зловживанням
Parliament is
податкового права
preparing to
взагалі, і,
implement
зокрема, у світлі
EU
статті 103
directive
Податкового кодексу, бо
and
це
changes
має
in the light
величезний,
of Article
звісно,
103.
вплив на економіку
All
нашої держави,
that
і
has
зокрема в умовах
negative,
воєнного
ruining
конфлікту.
impact on
І
our
крім
economy in
того, знаю,
conditions
що
of war
підготовлений
conflict.
спеціальний законопроєкт
I know a
працює щодо
special draft
зловживання
law
правом,
is being
і очікуємо на
developed
врегулювання цих
about
правовідносин, щоб
abuse.
можна було простіше, не лише на підставі
And
теоретики
we
податків,
hope
а й
that
на
it
підставі
will help
нормативних
us
положень
to use it
чіткіше відрізняти
practically
кондуїтні
and
компанії в даній сфері
differentiate
від
quickly
відповідного
transit
добросовісного користування
conduit
правом,
company
яке
and the
гарантується
honest
законом на уникнення
companies
подвійного оподаткування.
that
І
use
з
provisions of
великою
the law
приємністю
on
надаю
avoiding
слово
double
пану Голові для
taxation.
представлення
Now the
нашого
floor to
наступного
Igor
доповідача. Прошу.
to present
Так,
next
дякую, пані
speaker.
Ірино. І рухаємося далі.
Thank you.
Маю
We
честь представити
proceed.
наступних наших співдоповідачів.
Next
Це Євгена Михайловича
co-presenter
Смичка
Євген
та Сергія
Смічок
Вікторовича
and
Броякова.
Сергій
Отже,
Брояков.
Євген Смичок,
Євген Смічок, Associate Professor in the Department of Tax Law of Ярослав Мудрий National University. CEO of Bonalex Company, member of Scientific Advisory Board at Supreme Court, Doctor of Law.
Пан Євген належить до покоління українських
Євген belongs to generation of lawyers that combine fundamental research and practice of legal consulting and expert activity. He specialized in tax control and tax administration, facilitated new approaches in tax views. Being an expert or practitioner, he takes part in development of legal tradition in the tax law. Sergei Bryakov is assistant professor of the Department of Tax Law of the Yaroslav Mudry University and doctor of philosophy. He represents new generation of Ukrainian researchers of financial law, working on global transformation of tax systems, international standards, and mechanism of removing tax from tax-paying evasion of taxes. It reflects global tendencies of development of tax law. The topic is legal positions of the Supreme Court as an element of the mechanism for correcting systemic problems of tax administration. The floor is yours.
Доброго дня всім.
Good afternoon, everybody. Glad to welcome you to see colleagues. Igor Yaroslavich, great thanks for your warm words of introduction. That forces me to start thinking that life often has coincidences. The topic of our presentation with Sergei is based on the legal positions in your court judgment. And we did it non-intentionally. I do confirm it. Irina and I just discussed it, decided that we shall represent
Тому тут
this intent.
тези були відправлені Раїсі Федорівні ще
I
місяць
sent
чи
my
кілька
abstract
назад,
to
і тоді
Raisa
ще не було
months ago,
програми, так, виступу, і не було
and
зрозуміло, хто буде
agenda was not in
модератором
place. It
тієї
was
чи
not
іншої
clear
панелі. Але знов
who
таки
will be the
ж
moderator of this
життя,
panel.
воно таке
But
досить
life
дивне.
has such
Щодо
unexpected
нашого з
meetings.
Сергієм виступу,
As
про що
regards our
хотілося б
joint
взагалі
presentation with
розказати і
Sergey,
поговорити, це
what
про
I want
те,
to
з чим
discuss
ми,
with
на
you,
жаль, стикаємося кожного дня,
what
коли
problems we
в
face every
спілкуванні
day
з податковою службою в
when
Україні
communicating with the
починаємо
tax
говорити
service
і
in
доводити
Ukraine.
до
We
ті
start
питання, що а чому ви не
proving
звертаєте
them.
увагу на ті або інші
Saying,
положення
why don't you
податкового
pay attention to
законодавства,
certain
не тільки
provisions of
податкового
tax
законодавства і рішення
legislation,
Верховного суду, якщо
but
є
also
прямі
judgment of
норми,
Supreme
які
Court
це коригують
that
і регулюють.
contain
На
direct
жаль,
norms?
якихось
Unfortunately,
внятних, обґрунтованих з точки зору права
we never
відповідей
received
ми
any
не отримали.
clear,
Але
well-founded
більше так
responses.
забігаючи наперед, це буде блок
But
вже Сергія. Свій виступ ми розділили
Sergey will
приблизно
speak more on
на
that.
дві частини.
We
Я
divided our
відповідаю
presentation in
за
two parts.
практику
I'm
Верховного
responsible
суду,
for the
а
case
Сергій,
law of
відповідно, вже
Supreme
пройдеться
Court,
по
and Sergey
правозастосуванню
will
Державної
speak about
податкової
law
служби. На
enforcement
що
and the
хотілося б
work
звернути
of
увагу? Це те,
tax
що
administration.
забезпечення єдності правозастосованої практики в сфері податкового
Homogeneity of case law in tax administration is one of the preconditions to implement the principle of legal certainty and rule of law. Legal positions of the Supreme Court, which are sustainable, play the role of unified landmark in this activity. However, the case law shows that these positions are not always adequately implemented in the current activity of control in tax agencies. Discrepancies create systemic enforcement problems and dysfunction. I would like to review one of them, one of the challenges, which is cyclical in nature, the problem of tax administration, which is grounded in negligence of the positions of the Supreme Court, unfortunately. As regards regulatory justification, according to Article 171 of the Tax Code of Ukraine, it is established that the duty to register as the VAT payer appears if the total amount of transactions for supplying goods and services that are taxable according to this code are accrued over the last 12 calendar months, which exceeds 1 million hryvnias, without taking into account VAT. And despite clearly defined regulation in practice, there is a paradoxical situation. For the same provision, there are two opposite approaches. One is the position of the Supreme Court on one hand, and on the other hand, actual jurisprudence of the actual practice of the control agency, which ignores this legal position. The problem is in different understanding of the list of transactions which are part of the calculation of the threshold amount of this 1 million hryvnias. In the decree from the 27th of October 2023, in the case 520/19, 175/2020, the Judge Olender Igor Yaroslavich made the following conclusion. For the purposes of registration of the individual as the VAT payer, the total amount from transactions of supply of goods and services, which are subject to taxation according to Chapter 5 of the Tax Code of Ukraine, the transactions are accounted for which are taxable on the main rate, and the transactions which are taxable at the zero rate. The transactions which are not taxable with VAT and exempt transactions, according to Chapter 5 of the Tax Code, are not taken into account for identifying thresholds of 1 million hryvnias. This legal position became sustainable, stable, It is confirmed by the judgment of the Supreme Court in the case 486, where our judge, our colleague from the tax law department, Hoholak Vyacheslav Vissarionovich, when reviewing the judgments of lower instance courts, he states that consistent application of approach formulated in the case where the judge was Igor Yaroslavovich, and also referring to the judgments of Part 5 of on the law of Ukraine on access to court decisions, which empowers the judges to use information resources of a unified public register of the court decisions to ensure the homogeneity of enforcement practice. As a matter of fact, based on analysis and combination of these two judgments, we can see that the jurisprudence of Cassation Court is interrelated, sustainable. There are no issues about this, and regulatory framework is Part 5 of Article 13 of the Law on Status of Judges and Judiciary. The application of the provisions of the law and the judgments of the Supreme Court is compulsory for all public agencies which apply in their activity the regulations which contain appropriate provisions of the law. This provisions of the law is also systemic. It is highlighted and regulated in other judgments of the Cassation Administrative Court. However, I started my presentation somehow this Part 5 of Article 13 about compulsory nature of these opinions. This is forgotten by the State Tax Service for some reason. Why is this happening? Sergei Viktorovich will tell us in more detail about this. Sergei, thank you very much for giving me the floor, and it's a very interesting situation. The controlling agency, although legal positions of the Supreme Court are expressed, they're clear, according to Part 5 of Article 13 of the Law of Ukraine on Judiciary, they should be guided by this, and they just ignore it. STS just ignores it. Why? Because until now, in the database, the controlling agency insists on the opposite position, and they say that exempt transactions have to be taken into account when the threshold amounts are calculated in the amount of 1 million hryvnias. The tax office fully ignores the principle of legality and legal certainty. And taxpayer calculates the taxable amounts. If we move to systemic notions, it is a violation of the principle presumption of legality of the decisions of the taxpayer according to Article 4 of the Tax Code of Ukraine. And presumption of legality establishes clear rule that if there are two different interpretations of the same decision, even decisions of different hierarchy, this is how it is formulated. The decision has to be made in favor of taxpayer. This position is supported by the Supreme Court, mentioning that presumption is formulated according to the principle of Part 4 of the Tax Code of Ukraine. This establishes the highest level of imperativeness. For application, it is sufficient to identify two or more alternative options for legal behavior, selecting the most beneficial, and the taxpayer has to feel protected from potential negative consequences from the controlling agency and from the court. Moreover, this provision in the law covers not only expectations of the taxpayer. This presumption implements it as the main basis. Also, there is duty to choose the option of behavior and the controlling agents by the controlling agency and the court, and the burden of proof relates to the controlling agencies according to the law. This is the position of the Supreme Court and the judgment of 2022. This corresponds to the CHR case law, which is quoted by the Supreme Court in its judgment many times. Taking into account all this, ignoring of the legal position of the Supreme Court by the tax office creates a systemic problem. First, It violates directly and clearly and defined by Part 5 of Article 13 of the law of Ukrainian judiciary, the rules that public agencies have to be guided in their activity by the jurisprudence of the Supreme Court. This is purely logical because Supreme Court jurisprudence establishes landmark of application, including in the aspects when there is a legal uncertainty. If later on the public agency, including the tax office, adheres to legal positions of the Supreme Court, this a priori doesn't lead to appearance of controversial proceedings. Second, taxpayer, when they get the response they're not satisfied with, which if the answer is not good, it's not in line with the practice jurisprudence, they have to go to the court. They have to get their legal position confirmed by the court. Their position is also correct. It is in line with systemic practice of the Supreme Court. Only after this, the controlling agency will include as a new explanation the position which the taxpayer 1.5 years ago already received. Could have expected legally without all the court instances. We have third problem, which is unjustified burden on the judiciary, because courts are the first and second instance in the Supreme Court, and they get the cassation complaint from the tax office. They have to review in principle the dispute which has no prospects. The taxpayer doesn't have time and confirmation of legality of the position. They don't have clear understanding on the algorithm of behavior. Court system has additional burden on the disputes that are obvious because there is sustainable jurisprudence already. There are no doubts on how to calculate this threshold amount of VAT. For the ATP purposes, Supreme Court finalized this. It is confirmed in recent decisions. So there is a systemic problem which should be adjusted to make it impossible for the future to have this abuse, most likely. It is just the problem of systemic approach of tax administration at the level of executive authority which leads to this destruction in the rights of taxpayer and extra burden on the judiciary. Thank you very much for your attention. If you have any questions, we'll be happy to answer. Thank you, dear speakers. Again, Sergey, it was extremely interesting. And these issues are very important, urgent. Urgency is very high when we have frequent changes in tax law. Also, some ambiguity of application of tax law, application of legal positions, different interpretation by public agencies of some positions, including enforcement of the legal positions of the Supreme Court. The correct understanding of approach to enforcement of the positions of the Supreme Court, legal positions, play the key role in ensuring the homogeneity of jurisprudence and also removing gaps and contradictions in the tax administration. I would like to note that the value of this issue is in highlighting the role of legal positions of the Supreme Court as available efficient mechanism of adjusting the systemic disadvantages, drawbacks in enforcement, forming a legal certainty, protection of rights of taxpayers, balancing of interests of state and protecting the rights of taxpayers. It will promote also raising the quality of activity of controlling agencies. Thank you very much for this great presentation. And let's move forward. I pass the floor for moderation to Ms. Irina. Thank you once again. Thank you, Mr. Igor. If I may, I'd like to make a quick comment. Not only you are lucky to be quoted today by our distinguished speakers, but also our college was mentioned in the second part of the presentation. Thank you very much, Sergey Viktorovich. And also, I'd like to advise you to resolve this conflict. There is a great direct provision, Part 2 and Part 5 of Article 13 of the Law on Judiciary and Status of Judges, according to which For the controlling agency, the judgment of the Supreme Court is compulsory in the matters of enforcement of the provision of the law. But let's not stop on this anymore. Let's move to the next as important, as distinguished speaker, Oleg Vasilievich Pudus, who has unique experience of combining judiciary, scientific, and institutional activity. As the head of the court in frontline area, he ensures continuity of justice in the conditions of extraordinary security challenges, and recent experience of working in the Supreme Council of Justice allows him to directly be involved in reforming the system of judiciary governance in Ukraine. His professional activity demonstrates wide spectrum of balance between national security, the rule of law, and protection of human rights. The area of scientific interest of Oleg Vasilievich is also multifaceted. He has not only legal but also historical education. In addition to being a judge, he had the experience of being an advocate and teacher. He taught history, political science, and financial law in different universities of Ukraine. A candidate of legal sciences, associate professor, and our distinguished, respected colleague. Please, Oleg Viktorovich, you have the floor. You will discuss balance of interests of entities in tax relations and the role of the court in ensuring this balance. Good afternoon once again, dear colleagues. Frankly, after this great introduction, it's very difficult for me to add something, to say something. However, I will try to do so. Thank you very much. First, I would like to mention how quickly the time flies. I remember the first international conference in 2018. It was organized by a recently established Cassation Administrative Court as part of the Supreme Court. It was very solemn in Klovsk Palace. Everyone expected this. Everyone was looking forward to this. There was so much inspiration, so many guests, including international guests. And these memories inspire for going back to this ultimately. And my dream is that's next, or I'm not sure about the next one, but after all, we need to organize the Supreme Court, and we will help in this. We'll organize an international conference in Klovsk Palace in the peacetime, when there will be no more missiles, no more drones, and we will just take care, we'll hug each other, we'll smile to each other, and we'll be happy for rebuilding our favorite homeland. Going back to the conference and public finance, I believe I'd like to thank Ms. Raisa for choosing this topic for this year's conference, because public finance, in my view, not only in my view, but in the view of all our public officials, public finance is the foundation for the state, because the budget is the institution without which no state can exist. To ensure all functional areas of activity of the government, it is necessary to develop the budget and to have sufficient budget. And looking at in what way the budget is developed, we can count on development of areas of activity of the government. No doubt it is the key point which the government, one of the key aspects. Let's put it this way. It is one of the key aspects for the government to focus its activity. And when developing the budget, when preparing the budget, when in budget relations, one of the key matters and problems that appear. It is the challenge of contradictions between public interest and private interest. That is, between the government, which develops and tries to ensure the budget revenues, and the taxpayers, individuals and legal entities, which do their activity and they ensure the revenues of the budget and they help in the existence of the state. In the private sector, the taxpayers, the objective is to minimize taxation. The objective of the state, the public interest, is to maximize tax revenues and to accumulate as much tax revenues as possible. The key issue which has to be treated between in this contradiction is the availability of balance, the balance between public interest and private interest. The balance first shows the stability of the state, the prospects of the state, and if the atmosphere of balance is established, the balance between these key contradictions, this demonstrates that the state achieved some civilizational and civilized level. And this is a special concern for our states, in particular in the wartime, because the problems of development of economy are very painful at the moment, and especially presenting one of the key industrial regions of Ukraine, Zaporizhia region, I can say that the economy, no doubt, at the moment is declining, and we understand why. And so, to preserve this balance, preserving this balance normalizes even moral climate in the region and overall in the state.
Therefore, I want to address our legislator. I hope that Alexander, who is a member of parliament, today our final session has many representatives of Kharkiv Law School. Alexander, a well-known scholar and a member of parliament, must understand it. It's him who especially might listen to what we tell at this conference, since he is in the Committee of Finance and Taxes. Previously, he was a member of Advisory Council of the court. Members of parliament should realize our problems and then implement them in legislative draft. Main principles of financial and tax law. They must think that when shaping the system of taxes, of taxation, each tax must be well grounded and understood for any taxpayer. This is first thing. And second, the mechanism of levying taxes must be maximum understandable. What I'm leading to make impossible or at least minimize the conflict situation that arise now in our country between controlling bodies, the public administration on finance, and private interests. Each system of paying each tax must be so understandable that a company should not include too many accountants. The number of accountants and financial specialists more than any other specialist. Mechanism of relations between tax officials and taxpayers must be very well organized to avoid any possible dual interpretation. Again, to make impossible complex situation. Allegedly, all that is included in the tax code and code of administrative justice, they all contain this principle. But what we see is that number of tax disputes is not going down. The only reduction happens because in the martial law period, moratorium on checkups by tax authorities is imposed on particular operations, but number of tax verifications is great, and most of them end finally with a conflict between public administration, tax authority, and taxpayer. And legislators must pay attention to that, especially now in martial law with very high moral tension in society. They should take all these things into account and formulate such legislative norms that will make it impossible or at least reduce conflict situation. I had already mentioned what should be done. Taxes should be understandable, calculations must be clear, and there should be clear certainty how taxes are calculated, accounted, and paid, and clear relations between tax authority and taxpayer. But the main objective of my presentation is reduced to other thing. We are now, well, we're not celebrating maybe during the war, but at least we are marking days of administrative justice and emphasize the role that administrative court plays in the system of justice of Ukraine. This role cannot be over-exaggerated. In the system of tax legal relations between taxpayer and tax authorities, the role of an administrative court is the most important. That is the main focus of my presentation. What is important? If a taxpayer has not achieved compromise at the end of the checkup, he has the possibility to challenge tax decision. As of today, the role of administrative court in such disputes is huge. I will give you example in Zaporizhia District Court. By years, within last 8 years, 2018, disputes between tax authority and taxpayer, 76.9% decisions are taken in favor taxpayer. In 2019, 96% of decisions taken in favor taxpayer. 2020, 85.8, and so on. In 2025, 79.5% of judgment made in favor of taxpayers. These figures show, on the one hand, high authority of Ukrainian administrative court, not the my Zaporizhia court. That shows high trust to the court.
що так, суди захищають права
Yes,
суб'єктів
courts
приватного
do
права від
project
незаконних дій
to
публічної
protect the
адміністрації у сфері
interest
податкових
of
правовідносин, але
agent of private law,
цими
but
цифрами окреслити ту
when
проблему,
demonstrating these
яка
figures, I want to
існує і
emphasize
ніяк
what
чином не
huge problem
вирішується в
exists,
державі.
not
Це
being resolved in the state.
незаконність в більшості випадків
In most
рішень
cases,
податкових
unlawful
органів.
decisions of
І от
tax
якраз пані
authorities.
Ірина процитувала
Irina just quoted
закону про судоустрій і статус
article
суддів,
of the law on judiciary and status of judges about the duty of judges regarding interpretation of normal law.
сьогодні ця проблема, вона ніяким
Today,
чином не
this
намагається
problem in no way
проблема того, що
is
ці
being
податкові
resolved. Nobody
органи
tries to
не
resolve it.
виконують
Tax
те,
authorities
що
not only not enforce
інстанції,
judges of the first instance court, appeal
навіть
court,
правових
as
позицій
regards
Верховного суду.
interpretation.
Тому що
They
дуже
even
багато
do not
спорів
enforce
виникають
positions of
з
Supreme Court.
аналогічних питань, де
Many
правові позиції Верховного суду просто
new
нівелюються
disputes
податковими органами. І
come
якраз
on the
в
same
цьому
problems.
контексті
Uh,
сила
and we see that tax authorities disregard conclusions made by Supreme Court. On the one hand, our legal practice is consistent, and this is good. But all that
повинен бути наслідок, який
shows that there should be some consequences of decision taken by Supreme Court. At the level of government, decisions should be taken to change the situation drastically and change authorities conceptually change their position. Next, what else I want to say? As regards balance of rights of public administration, private sector in legal tax relations. Some time ago, when passing a law on amendments to the tax code regarding control on transfer pricing and use of tax compromise of 2014, introduced such an institute as a tax compromise. In my view, we must start thinking, members of parliament must implement it at legislative level. This institution must be introduced. I remember when it was applied, that helped to resolve numerous conflict situations at pre-court stage. This legal institute of tax compromise is very effective, and I think one should come back to it. When talking about role of administrative court in resolving disputes between tax administration and taxpayer, I would have emphasized attention at such things. Possibility to use institute of reconciliation. It is in the Code of Administrative Justice, Article 190 and 91, as regards tax legal relations. At least I know few cases when at the stage of trial, the parties reconcile. Although, as I see it, well, what is the reason of that? The problem is not in taxpayers, but rather representatives of tax authorities. Tax authority, I do understand, it's not a desire of a particular authority, particular official. I mean, entire system of state authorities attitude. Therefore, these things must be specified in legislation. Tax authorities are afraid of using this institute tax compromise, arguing that they don't have legal mechanism. And I think members of parliament should think about that, given possibility to tax authority to use this institute as reconciliation at the party at the stage of court consideration. This is in fact the continuation of tax compromise, but already at the stage of judicial procedure.
Ну, скажімо, дуже часто розглядають, що податкові
This
збори,
institution would be
платники
very effective.
податків
Very often
готові,
it happens
готові йти на якісь
that
поступки, але
taxpayers are ready
бажали
to make some
очікувати і
concessions,
поступки з боку
but they
держави в
would
особі
like
податкового
to
органу.
get some
Але
concession
податковий орган
from
заявляє,
tax
що він
authorities.
не
But tax
має
authorities
такого
said they don't
інструменту,
have
не має
legal
такого
instrument.
права,
They don't have legal
нормативного
provision
права, якраз нормативного.
regulating
І
that.
тому
It's rather
фактично цей інститут
regulation that
примирення
they need.
сторін на
And this
стадії
Institute
судового
of
розгляду
Reconciliation of
сьогодні
Parties at the
фактично
stage of court procedure,
майже мертвий.
in
От
fact,
мені
is
б
dead.
хотілося звернутися до якраз
I would like to
учасників конференції
address
народних депутатів.
participants of the conference, members of
Щоб
parliament.
Руслан був Стефанчук,
If
до
Ruslan
нього,
Stefanchuk could be here,
якраз
I would like
щодо
to
надання
appeal personally to
можливості
him
податковим органам
about
на стадії вже розгляду
giving
судової справи
possibility to tax authorities
використовувати
at the
цей
stage of
інститут
court
примирення
procedure
сторін.
to use this Institute of Reconciliation of
Говорячи
the
про
parties.
якраз баланс між публічним інтересом і
Talking
приватним
about
інтересом,
balance of public and
ми
private
безумовно посилаємось
interests,
на
we refer
статтю 1 протоколу
to
1
Article 1
Конвенції
of Protocol 1 of
по
European
захисту прав людини,
Convention
основних
on
свобод.
Protection of
Але
Human Rights and
такий
Fundamental
момент,
Freedoms.
ми всі пам'ятаємо
But
частину
one thing
другу
more, we
цієї
remember part
статті,
2 of this
відповідно до
article,
до
according to
якої
which
держава має
the
право
state has the right
фактично контролювати
to
власність,
control
контролюючи
property
наповнення бюджету, тобто
by
здійснюючи
controlling
заходи,
revenues to the
здійснюючи
budget,
контроль
taking
за
measures, taking
використання майна
control
відповідно до загальних інтересів задля забезпечення сплати податків.
for
Тому
the sake of common
норма,
interest to
яка,
ensure tax
скажімо,
revenue. This is a
дозволяє
norm that
однозначно
allows
тлумачити захист права
to
власності.
interpret
Першу
protection of
Конвенції.
right of property
Але
ambiguously.
цьому все рівно
However,
частина перша, вона
part 1 of
є
this
головною і вона
protocol,
визначає
Article 1 of
право
Protocol 1,
саме захисту власності,
defines
чесного
the
платника
right
податків
of
і
taxpayer to protect
втручання держави
use of her
має
property,
бути
and interference of the
пропорційним,
state must be
пропорційним
proportional
щодо контролю і взагалі
as regards control
контролю
exercised.
сплати податків платником податків.
Control over
Дуже дякуємо вам.
taxation. Thank you very
Васильович.
much,
Я так
Oleg
розумію, що час я
Vasilyevich.
перебрав.
I understand I have
Вже
exceeded
правами
my
і
time,
обов'язками модератора.
using
Я
not
буду
only rights
рахувати,
but
що ви на
duties
такій
of
оптимістичній
moderator. I will
ноті,
start thanking you. It's very
завершили
good that
нашу
you
Я ще
concluded
два слова, пані
your
Ірино,
final
тому що
presentation such
це
optimism. Only
стосуючись
couple of
теми
words
своєї
more.
доповіді. Я
Not regarding
думаю,
my
що
topic.
всім
I
зрозуміло
think
і
that it is
були
clear
почути
for
те, що
all.
я говорив, бо всі
Everybody
цій
is
сфері
concerned
працюють вже
about
багато
things that
років,
I
ті, хто
described.
розглядається
I'm
з
working
цього,
in
хто
this sphere for many years,
практикуючі юристи, представляють
both the
інтереси.
scholars
Я
and
зараз
the
про інше. Я
practitioners.
хотів би
I mean
особисто
other thing. I
і
want,
від свого колективу
on
подякувати
behalf of
організаторам
me,
конференції
myself, and
за
of my
про
court, to thank
те, що
organizers of
актуальність
conference
і дуже важлива
because
про
you chose
організацію на
very
найвищому
up-to-date
рівні.
topic.
Просів
Conference is
модераторів
organized at very
і
high level.
безумовно
I
я
want to
пані
highly
Наталю, вона вчора
assess
модерувала,
all
я не можу її
moderators.
оминути, але
Natalia
сьогодні в
was
нас
moderating
модератори
yesterday. I
пані Ірина
must
і пані
mention her.
Ігорю.
Irina
Велика вам
and Igor,
подяка.
who are
Ви
today's
супер, ви
moderator,
найкращі.
great
Я
thanks to
думаю,
you.
що
You
ця
are super. You
конференція,
are the
якщо
best.
її тільки
And I
подивилися
think
наші
if this
законодавці,
conference
які
is watched by
висновки з цього зробили,
legislate and
була
made some
просто
conclusions,
супер. Всім
that
дякую.
would be
Дякую
super.
особисто
Thank you
Раїсі
all.
Федорівні вам
Personal
і
thanks
голові
to
нашого
Raisa
касаційного
Fedorivna
адміністративного
and
суду
the
в складі
President of
Верховного суду
Court,
пану Ігорю Дашутіну.
Mr.
Всім велика
Dashutin.
подяка і до миру.
Great
Дякую.
thanks to you. Hope to achieve
І ми вам
peace.
дякуємо.
We
У
also are
нас по
thankful to
програмі
you.
зараз
According to the
має бути
program,
обговорення.
we
Проте
must
Олег
have
Васильович
discussion.
фактично вичерпав
However,
відведений для цього час.
Oleg
Якщо є у
Vasilyevich
когось короткі
used this time
ремарочки
for
чи
discussion.
якісь
If you have just
певні
brief remarks
рефлексії на
or
виступи
short
дослідників
reflections
цієї сесії,
regarding all
прошу про це розговоритись
presentations,
або
please
мовчати про це
raise your
тихій
hand
голосі.
or rather be silent.
Якщо я не бачу піднятих рук,
I don't see
то
hands
подякую
raised.
вам за
Then
те, що
I will only
доповіді
thank
усіх
you
наших
all.
учасників-доповідачів були
I
глибокими,
want to thank
вичерпними,
all
раз не погрожують
presenters
ні
for very
сумнівів, ні
profound
обговорення,
and exhaustive
за сміливцю
presentation
висновка,
that
за
do
глибину,
not
обґрунтованість, за
cause
професійну
questions.
єдність.
I want
Ми
to thank
бачимо,
you
що
for
попри всі
your
серйозні
profound
виклики,
conclusion,
наукова та
for
суддівська
your
спільнота є
serious
консолідованими. І що
outcomes,
і законодавець,
and we
і
see that our
доктринальні
judicial
підходи, і
community is
правозастосування на
consolidated.
рівні суду
Both academic
ефективно і
research and
своєчасно
practical
відгукуються на
conclusions
усі ці
work
виклики
effectively,
галузей права стають більш
responding
зручними,
to
а
the
правозастосування
challenges.
більш технологічним і
So
більш
it becomes more
людиноцентричним.
flexible and more
Для підведення
human-centric.
підсумку нашого
Now
заходу з
I
великою
invite,
приємністю і маю за честь передати слово голові нашого суду
give the floor to
Ігорові
President our
Володимировичу
court,
Дашутіну.
Igor Doshutin, to conclude the conference.
Дякую вам, Ірина Леонтівна.
Thank you, Irina.
Я, знаєте, багато навіть
You
хвилююсь,
know,
тому що
I'm a little bit
для мене
nervous.
це велика честь
For
взагалі
me, it's a
приймати
great
участь,
honor to take part
бути співорганізатором такої
and be a
міжнародної конференції,
co-organizer of this
яка, на
international
мій погляд,
conference that, in my
дійсно
opinion,
пройшла дуже успішно.
was very
Велика
successful.
робота пророблена,
Huge work done
і
for preparation.
формат ми постійно намагаємося змінювати,
We are changing,
щоб було
trying
цікавіше,
to change format all the time to make it more
більше
interesting and
було зацікавлених
attractive,
осіб, і
to
ми
have more
з організаторами
stakeholders.
фіксуємо збільшення
And we
кількості
see
звернення,
that
і
number of
сьогодні навіть
participants
другий
is
день,
growing.
п'ятниця,
Today, it's
ось
Friday, the
якісь
second day of the
можливо,
conference.
вже плани свої.
People have some
Зрозуміло,
plans
що
for
це
weekend,
п'ятниця і на вулиці
but
36.
still more and more people
Але ми
are
бачимо все
joining.
рівно
So we
високу
see
активність і
very high
зацікавленість
activity
до цієї
and
конференції.
interest to this conference.
Ну, але, на жаль, добігає завершення.
Unfortunately, the conference runs to an end, and we can say convincingly that those 2 days became the space for open professional dialogue between
між суддями,
judges,
науковцями,
scholars,
представниками органів державної влади
representatives
та
of
нашими
public agencies,
міжнародними
and
партнерами.
our international partners.
Дякуємо кожному, хто долучився до
I
цієї
would like to thank
конференції,
everyone who was involved in the
цими
conference
доповідями.
with presentations.
Я хочу також зауважити, що
Also, I'd like to
доповіді
note
всі
that
були дуже
all
цікаві,
presentations were very interesting, charismatic,
активні,
creative,
і
and
ми відчули якийсь новий
we
подих,
felt
свіжий
new
подих
inspiration,
нових ідей,
fresh spirit of new ideas,
нову термінологію.
new terminology,
І на такому професійному
and
рівні
at this professional level,
піднесено,
all this
донесено
was
до
delivered to
слухачів.
the audience.
Як колись говорив мій перший керівник,
As my first manager used to say,
самі тяжкі
the most
професії
difficult professions
взагалі у світі
in
це
the world are
лікарі, вчителі
doctors, teachers,
і судді.
and judges.
Тому що всі вони приймають
All of
рішення.
them are making decisions.
Лікарі
Doctors
рятують людей,
save
судді
lives.
приймають і вирішують долі.
Judges
Вчителі
decide on
навчать,
destinies.
то і
Teachers
буде, те і буде нас майбутнє.
produce
І сьогодні
people
судді
for the future.
адміністративної
And today,
юрисдикції, юстиції
administrative
продемонстрували
justice
професіоналізм,
judges demonstrated
неабиякий
professionalism,
професіоналізм у підготовці до
extraordinary professionalism in
цього
preparation for this event,
а участь науковців і
and participation
представників
of scholars
органів
and
державної
representatives
влади.
of public
Також
agencies.
відчувається, що була
We can
велика
also feel
зацікавленість
that there was
і
great interest,
дало можливість зануритися нам
and it
навіть
allowed us
в
to
наші якісь
dig deep
студентські роки, тому що
into
сьогодні
our students' years, because today
доповіді виступав
we had a
Кучерявенко,
presentation from
Ірина Леонтівна і взагалі хто
Irina Kucherenko and
навчався в
those who
юридичній
started
академії,
in legal academy.
Альма-Матер, то ще був
If it
нашим
is your alma mater, you can
викладачем.
understand this.
А зараз для нас велика честь
And now it's a great honor for us
з ним вступати в полеміку,
to
задавати
have
йому питання
discussion,
вже
to ask
в іншому
questions to our former
статусі.
teacher, now in different status.
Судді інших юрисдикцій
And judges of other jurisdictions were very interested in this
хоч у
activity.
нас і є там
Although we have some
непорозуміння якісь з юрисдикційних питань,
misunderstandings on jurisdiction matters, and even when we were fighting
податки не можуть
to make sure that
розглядати
taxes cannot be
і
considered
спілкувалися
under insolvency, and when we talked to commercial jurisdiction judges, they agreed
навіть коли
that
вони там
even when they
час намагалися переглядати ці справи, але
tried to review
все
those
ж таки
cases for some time,
керувалися нашою судовою
they were
практикою,
guided by
тому
our
що
case
цих
law
справ
because
там більше ніж до відсотка. І коли
it's less than 1% of cases.
починається фахова дискусія,
And
навіть по
when the
закону про
professional discussion
адмінпроцедури,
starts on
і
the
взагалі
law on
по
administrative procedure,
як це стосується
and as
конкретно
concerns
нашої теми
specifically our
сьогоднішньої,
today's
то
topic,
все ж таки всі звертаються до
all
суддів адміністративістів
apply
саме
to administrative
за фаховим
judges for
висновком
professional
в цій
opinion
темі, тому що
on
ми
this topic
дійсно
because
глибоко занурюємося
we
в ці
delve
проблеми,
deep into
і
these
тема
problems,
публічних фінансів,
and the topic of public
фінансового
finance
війни є
and the conditions of
надзвичайно
war
складною.
is
Вона
extremely
не має
complicated.
простих або
It
універсальних
doesn't have
відповідей.
simple or universal
Але саме тому
solutions, and that is
цінними
why
є ці зустрічі для нас,
it is
під
valuable to
час
hold
яких
meetings like this,
формується розуміння
during
того,
which we
якими мають
create
бути правові
understanding
механізми,
on
здатні
legal
забезпечити
mechanisms
і потреби
capable
держави,
of ensuring the
належного
needs of state
захисту
and
прав
proper
людини.
protection of human rights.
Також під час цієї
Also, during
конференції
this conference,
значну увагу приділена податковій
great attention
політиці,
was focused on
бюджетним
tax
процесам,
policy, budgetary
судовому
processes,
управлінню, європейським
judiciary
стандартам,
control, European standards,
сучасним викликам
and modern
адміністративного
challenges in
судочинства.
administrative
Усі ці
justice. All
питання
these
різні за
matters
змістом, але
are different in
об'єднує
content, but
одна
they are
спільна
united
мета
by
– це
one common
забезпечення
objective
довіри
to
до
ensure
держави
trust
через
to the
верховенство
state
права.
through the rule of law.
Саме судова
The
влада
judiciary
має забезпечити,
power has to
щоб
ensure
навіть у умовах найбільших
that even
випробувань
in the conditions of greatest
закон
trials,
залишався
the law
однаково
remains
обов'язковим
the
для всіх,
same
а
for
державні
everyone,
рішення
and the
вони не
state
лише
decisions are not
а й
just
справедливі.
effective but also just.
Для України це має особливе значення, оскільки
For Ukraine
сьогодні
has
ми
special
будуємо
significance because
сучасну
today
європейську
we
систему
build modern
правосуддя,
European system of justice
здатну
capable
відповідати на виклики
to
воєнного
respond to
часу,
challenges of the
не
wartime,
відступаючи від фундаментальних демократичних
not
цінностей.
derogating from democratic values.
Переконаний, що
I'm convinced that
ідеї, висловлені під
the
час
ideas
цієї
expressed during this
конференції,
conference
знайдуть обов'язково
will find
практичне продовження
practical
у наукових дослідженнях,
continuation in
законотворчій діяльності.
research
Судовій
in
практиці,
legal drafting and
оскільки
jurisprudence,
з нами сьогодні були
because
присутні
today we had
видатні
leading
науковці і
scholars with us
законотворці,
and
які
also
постійно тримають
legislators
на пульсі
who keep
всі державні
the hands
процеси
on
в
the pulse of
Україні,
all
що
state
стосуються
processes in
податків.
Ukraine as regards
Тому що кожен з
taxation,
нас,
because each
кожен
one of us
законотворець і
and each legislator
науковець розуміє,
and researcher
наскільки
understand
важливо зараз
that how important it
підтримати
is to support
всі бюджетні програми
all budgetary
і
programs and
знайти кошти на всі ці
to
програми,
find funds
і
for all
взагалі
programs
для
and
відновлення нашої країни,
overall for the recovery of our
наскільки
country,
важливо.
how important it
І
is.
висловлюю вдячність,
And I'd like to express
звісно,
gratitude
організаторам цієї
to
конференції,
organizers
усім
of this
спікерам,
conference, to all
модераторам.
speakers,
І
moderators.
вчора, і сьогодні це
Yesterday
було
and
дуже
today,
креативно,
this was very
харизматично.
creative, charismatic.
Просто не можу навіть інколи і
I
висловити
cannot even
своє
express
задоволення,
my
наскільки я був
satisfaction,
задоволений.
how deeply I was
Я
involved.
відклав всі свої плани, всі
I postponed
справи
all my plans,
і
all
був тільки
business, and I was
занурений в цю
just
конференцію. Тому
immersed
Раїса
into this
Федорівна
conference. Raisa
і
Fedorivna and
Вячеслав Виссарионович, і
Vyacheslav
Наталія
Vissarionovich and
Євгенівна,
Natalia Evgenievna and
і
Irina
Ігор Ярославович.
Leontievna and
Всі
Igor Yaroslavich
і наші
and
працівники
our
апарату, вони
staff
були
members
долучені до цих
were
процесів.
involved in
І
these
всі наші
processes
міжнародні
and all our
партнери.
international partners.
Ми пам'ятаємо і
We
розуміємо, що
remember and
навіть
understand
ті
that
наші
even
друзі,
those
міжнародні
friends,
партнери, які
international
постійно
partners
приймають участь у всіх конференціях,
participate in all
вони знайшли
conferences,
час
they found time
ми точно знаємо, як це
And
було
we know
важко.
for sure how
Вони
difficult it was.
навіть припиняли десь свої
They even
відрядження.
stopped their
Дуже,
business trips,
дуже
their
відповідально
missions.
віднеслися
They were
до
very
цього важливого для
responsible
нас
in their
моменту цієї
attitude to this
конференції,
important
тому що ми
conference for us.
готували до неї
Because we
тривалий
were
час, і дуже було
preparing
важливо,
to this
яким же
conference for a long
чином
time, it was
це
important
все відбудеться, і
to
як
ensure that everything
кожен
is
з
organized
присутніх
properly,
і
and
ті, хто
each participant and
доповідачів
those
віднесуться до цього.
speakers
Тому
should have the right
дуже
attitudes.
сподіваюся, що
So
дискусії
I really
започатковані
hope
тут
that discussions
матимуть
initiated
своє
here
продовження
would have their continuation
і нові професійні контакти, які
and
ви
new
тут
professional
всі
contacts
отримали,
that you received here
переростуть у
will grow
довготривалу
into
співпрацю.
long-term cooperation.
Хочу побажати всім
I would
миру,
like to wish
наснаги,
peace,
професійних
inspiration,
успіхів і
professional
нових
success
зустрічей
as
вже
new
на
meetings
10-й ювілейній
at the
міжнародній
10th
науково-практичній
Jubilee
конференції.
International
Хочу подякувати всім
Conference.
за
I'd like to
увагу,
thank everyone
плідну
for your
роботу. І
attention,
зараз
fruitful
я
work.
завершую
And
свою
now
промову.
I finish my speech.
Можливо, вона трошки емоційна, але
Maybe
повірте,
it's a bit
це
emotional, but
щиро.
believe me, it
І
is
я
sincere.
хочу
And
передати слово
I want
Раїсі
to give the floor to Raisa
Федорівні
Fedorivna
Хановій.
Khanova.
Дійсно,
This is
для багатьох
for
наставник
many,
в
this is the
податковому праві
teacher in the
сьогодні
tax law.
важко
Today it is hard to find
більш фахову людину,
more
ніж
professional
Раїса
person
Федорівна, тому що
than Raisa
вона
Fedorivna,
постійно працює з цими
because she works with
конференціями,
these
з усіма
conferences all the
темами,
time, with
і
all
дуже
topics,
ретельно
and
підбирає
she
теми
thoroughly
цікаві.
selects topics interesting.
У нас дуже сильна команда, тому Раїса
We have a very
Федорівна,
strong team,
будь
so
ласка,
Raisa Fedorivna,
вам
Raisa
слово.
Fedorivna, the floor is yours.
Дякую, Ігор Володимирович.
Thank you, Igor Volodymyrovich.
Ну що, дійсно, як сказала Ірина Леонтівна,
As Irina Antonina rightly mentioned, everything is positive and all good things to finish very quickly.
кожному, хто долучився
Thank you
до
much to
нашого
all of you
9-го
who were involved in our
міжнародного
9th International Conference.
Цього року ми об'єднали
This year we
українських,
united
європейських
Ukrainian,
експертів
European
навколо
experts
найважливішої
around
теми
very important
функціонування
topic of
публічних
functioning
фінансів
of public
та
finance in the conditions of
адміністративної
war.
юстиції в умовах війни. І ми бачили, що
And
ми
we have
самі
seen
по-іншому
that
мислити стали в деяких
we started to
питаннях.
think
І
differently in
наші
some
друзі,
matters, and our
наші
friends,
спікери
our
вчора,
speakers
сьогодні
yesterday,
також
today
на цю проблему
also
подивилися дещо
looked at
під
this
іншим
problem
кутом.
at
Дякую
different
спікерам за
angle. I'd
розумні
like to
доповіді,
thank the
міжнародний
speakers for
досвід,
informative presentations,
чіткий
international
погляд
experience,
на
clear
виклики
answers
сьогодення.
for the challenges
Наша
of today.
четвірка модераторів були
Our top four
неперевершені.
moderators
Я
were
просто, в
exceeding
захваті від
expectations.
того, як
I'm
все
really happy
вийшло.
with how
Всім
everything worked out.
організаторам за високий рівень
I'd like to
підготовки
thank
та
all organizers for
технічне
high level of preparation
забезпечення.
and technical support.
Дякуємо щиро
I'd like
команді
to sincerely thank the
перекладачів за
team of interpreters
професіоналізм,
for professionalism
лінгвістичне забезпечення
and
нашої
linguistic supports of
конференції.
our
Саме
conference.
вони помогли
They
нам
helped
почути
us
і
to
зрозуміти
hear and to
один
understand
одного,
each
незважаючи
other
на якій мові ми
despite
вели
the
свої
language we
доповіді.
were using for our
Особлива
presentations.
подяка, і я
Special
підтримую Ігоря
thanks and I
Володимировича.
support Igor Volodymyrovich.
Треба засвідчити працівникам
Special
апарату
thanks
касаційного
goes to the
адміністративного
staff
суду
members
у
of
складі
Cassation
Верховного суду,
Administrative
тому
Courts
що їх невидима,
because
але
they're
фундаментальна
invisible
робота
but
з
fundamental
організаційного
work
забезпечення
on
стала
logistics
запорукою
was the
бездоганного
guarantee
та
of
чіткого
seamless and
перебігу
clear
нашого заходу.
run of our
Ця
events.
конференція іще
This
раз
conference
продемонструвала. Ігор
demonstrated once again,
Володимирович, ви маєте
Igor
команду.
Volodymyrovich, you have a
Разом
team.
ми формуємо
Together we
стійку
form
європейську
sustainable
правову
European
систему
legal
України.
system of Ukraine.
Окрему увагу дозвольте
Special
звернути на
attention,
видавничий доробок конференції,
I'd like to draw
який
special attention to
представлений
scientific
такими
development of the conference
фундаментальними
presented by
тезами.
fundamental works.
Збірник тез,
The collection of
доповіді,
points
58
of presentations,
доповідей.
58 presentations.
Завдяки ОБСЄ ми його
Thanks to
видали.
OSC, we published
Тут не
this.
тільки доповіді, які ви сьогодні
It's not only
чули,
presentations
суддів
that you have heard
Верховного
today
суду,
of judges of
суддів
the Supreme
першої
Court, of judges of
апеляційної
the first and
інстанції.
appellate
Ми
instance.
жодну доповідь не повернули.
No
Рівень
presentation was
був
returned.
настільки
The level was
високий,
so
і
high,
зауважень було настільки
and
мало,
we had
що
so few
все
comments
розміщено.
that
Тут
everything is
є
published in
докторанти,
this
тут є
book.
аспіранти,
We have
тут є
doctorants
адвокати,
and aspirants
тут є
and lawyers.
працівники
We
державних
have staff
органів,
members of public
які
agencies.
також суміщають
We
роботу в
also combine
державних
the work
органах
in the public
і
agencies and
викладацькою науковою
teaching
діяльністю.
and research.
І я дуже вдячна нашій
I'm
академії
very
Харківській,
grateful to
5
our Kharkiv
травня
Academy.
вони
On
провели
May
це
5, they
через вчену
conducted
раду.
this through the
Завдяки команді
Scientific Council.
наших
Thanks to the team
правників,
of our lawyers of
ми
legal
зробили
department,
з вами
we
продовження
produced
такого
the
збірнику
continuation of this
ілюстративних
collection
матеріалів
of article materials
22-25 роки,
22,
які є
years
продовженням
2022,
першого нашого
2025. They are a
видання
continuation of our first publication,
18-21 роки,
2018-2021,
доповнений QR-кодами для
added with QR
зручного
codes for
пошуку матеріалів.
convenient search of
Кожна
materials.
стаття – рішення
Every
Верховного
article is the
суду
judgment
і
of the Supreme
QR-коди.
Court and QR codes.
Робочу групу, оскільки
And the working group,
використано тут
as
рішення
they use the
судів
judgments of the courts,
соціальної і
social,
вищої палати
the
вирішили
electoral
наші
chamber.
шановні
This
секретарі
includes
цих
our
палат, а
distinguished
інші
secretaries
склади
of the
ви
chambers.
побачите.
And you can see the rest of the composition. Also, we have done
виданий, що є
and
особливою
published,
нашою
which is
гордістю.
our special pride. The full new text, bibliographic, indicates classifier of laws and regulations in official periodic publications,
революції та національного
an
державного
anniversary of Ukrainian Revolution and state building of 1918-1921, the legal regulation of public finance. I would like to say that we found 8 publications at that time, thanks to our former literary editor, Christina.
Кожне видання
Every
вичитали,
publication
відібрали
was read, and we
110
selected
нормативних
158
актів тої доби
regulations,
і
so that's
відтворили.
age, and we restored
Коли ми
them.
це робили,
When we were doing
це був
this,
амбітний проєкт,
it
і
was
він
ambitious project, and
реалізований, я
it
вважаю,
was implemented properly to
що
demonstrate
ту добу,
that at that time, in
17-21
1917,
минулого століття,
1921,
Україна, Українська
Ukraine,
Народна Республіка
Ukrainian
була,
People
вона була
Republic
визнана
existed. It was
44
recognized by
країнами
44
світу.
countries in the
І
world.
якщо ви звернетесь до
And
перших
if you
джерела,
look at
а
the
ми тут
primary
від себе,
source
крім
and
передумови і показчиків в кінці, а
where
також
added on the forwards
глосарія
and also
термінів колишніх,
list
ми
of
нічого не
terms
добавили. Ми
and
стилістику,
content at the
слова
end.
все зберегли.
Stylistics and
І
words were preserved.
відтворили це для того,
And
щоб
we created
показати,
this to
що
demonstrate
Україна, вона
that
не сьогодні
Ukraine
народилася,
was
вона
not
була,
born
в неї
today,
є
it
своя
existed, it has
законодавча
its
база,
legal
в неї є
framework,
своє правове підґрунтя.
it has its
І
legal
це
foundation, and
знаєте, противага отому гаду, який
it
доводить,
is
що Україна ніколи не
counterpoint
була
for
державою.
that
Тому
bad
що
guy who
рівень
proves that Ukraine never was a state,
нормотворчості
because
того
the level of
часу
legal drafting at that
держави
time
і
and the
зацікавленість
state
в
and
державних
interest
інститутах, вона
and
вражає.
the public institutions
І
is impressive.
наостанок, що
And at the
вдалося
end,
зробити?
what we
Журнал
managed to do,
дитячих малюнків.
the journal of child's
Отак, покажу,
paintings.
буде вам видно зараз.
I'd like to show this.
Касаційним адміністративним
Cassation
судом
Administrative
було
Court
організовано та проведено
organized and conducted
всеукраїнську виставку
all
конкурс
Ukrainian
дитячих
exhibition
малюнків,
competition of
подарки
child's
в кольорах
paintings,
дитинства. Метою
taxes in
виставки
the colors
конкурсу
of
є
childhood.
популяризація
The objective is to
адміністративного
promote
злочинства,
administrative
формування
justice,
правової
to form
свідомості
legal
та
consciousness,
виховання в
and to
дітей культури
educate
відповідального
culture
платника
responsible
податків.
taxpayer
Було
among children.
представлено 60 малюнків з
60
різних куточків
pictures were
країни і
presented from
навіть
different
за
parts of
кордону.
the country and even
Вікова
from
група
abroad.
з 5 до
The
17
age group
років.
is 5 to 17 years.
Запрошую вас
I
поринути в
invite you
світ
to
дитячої творчості,
go
переглянути
into the world
відео
of child
та
creativity, to
побачити
review the
серйозні
video, and to
державні
see
теми
serious
крізь призму
state topics
дитячої
through the prism
творчості.
of
Будь
child
ласка.
creativity, please. Taxes in the colors of childhood, taxes, part of the whole. Taxes equal clean environment.
Кожна дитина, яка приймала участь у конкурсі, отримає диплом, підписаний Ігорем Володимировичем, і отакий альбом. Також кожен спікер наш отримає весь комплект, який я щойно продемонструвала, з 4 видань. На цьому наша конференція добігла кінця. Завершити
This is
хочу
the
рядками
conclusion of our
Стефана.
conference, and I want
Велике
to
діло писані
end
слова.
with a poem
Історію
of Lina
пишуть на
Kostenka.
столі. Ми ж
History
пишем
is being
кров'ю на
written
своїй
on
землі.
table. We are
Ми
writing
пишем
history by
троном,
blood
шаблею,
built on our
мечем,
land, by
піснями,
a saber,
людським
by
плачем,
a sword,
могилами
and
у полі без
crying and
Ці
graves
геніальні
in the
рядки
field.
сьогодні відгукуються в серці
These
кожного з
genius
нас,
words of
хвилюючого
Lina
редактора.
Kostenka
Як суворе,
resonate in the heart
адже
of
ми знову
everybody
відстоюємо
as
своє право
hard
жити і
reality. We
творити
defend
на
our
своїй
right
землі.
to live
І
and to
ще раз
work
дякую всім за увагу.
creatively in our
Маю честь
land.
сказати
Thank you
це
all again
слово
for
завершальне, за що
participation. I
безмежно
have the order
вдячна
to make
Ігору
these
Володимировичу.
concluding
За
words.
зрозумілих
Great thanks
причин
for
це
Igor
моя остання
Dashutin for that.
конференція, як
For
в межах
understandable
і
reasons, this
адміністративної
is my
юстиції.
final
Із
conference
задоволенням
within
передаю
sphere of
естафету наступній
administrative
нашій
justice.
соціальній палаті
And
нашій
I'm happy to
правоохоронній
give it to the
Бажаю всім
next
вистояти і
chamber,
вижити
social
в цій
chamber
непростій
colleagues. So
війні.
I wish you
Як
all to
кажуть,
survive in this difficult
залишайтеся
war.
з Богом. До нових зустрічей.
Let God help you. See you soon again.
До
Дуже
побачення.
дякуємо.
Goodbye.
До побачення.
Дуже дякуємо на все добре всім.
Thank you very
До
much indeed.
Дякую, до
Goodbye.
зустрічі.
До зустрічі.
Дякуємо. Усім дякую, до побачення.
Thank you all. Goodbye.